Good morning, everyone. How are we? Good morning. I think I'm on delay. Oh, Kona's mom has the scoop. Yeah, so here was what I did, guys. I put it at 8:30 because I was thinking that's when they said it started, but actually that is actually 9:30 my time. So I do apologize. I am awaiting them to open the webinar. Right now it's closed. Nobody's scared of you, Kona's mom. She said everybody's scared to talk to me because I never shut up, but I'll be quiet today. Girl, you're fine. Yeah, so Kona's mom was saying that sh- h- Gannon's mom, biological mom, and Letecia hated each other because Letecia, wait, where'd you put it at? Was married. Letecia was married to Gannon's biological mother's brother. Oh Lord. Hi there, Suzanne. Welcome from Amsterdam. That's so cool. Oh, that's awesome how we can connect. What time is it in Amsterdam? The Netherlands. Oh, that's right. You guys go by military times. All right. Well, I'm just waiting for this webinar to begin and then I'll turn it on for you guys. And then let me try to join it one more time. Oh, they got it. No, wait. It just keeps saying it hasn't started yet. So here's what we're going to do. I'm going to have that on live stream for you so you guys can hear that. And then I am going to get we've got somebody over at Crafts and Chats with Vets is watching the Fuji trial for us today. Well, actually, it's not the trial; it's the sentencing area. So it's the sentencing portion of his phase, and that's interesting because I guess they're going to have some. I know, like right now, the detective is speaking, just kind of giving everybody or giving the judge the down low of what happened. And it's so cool because it's not like in front of a jury and it's just in front of a judge, so it goes by way quicker. But I think then they're going to have some victim impact statements today as well. So we're going to try to cover that after this stream is over. It's just going to be a lot going on, and I just don't want to take away from what we got going on over here. So we're going to be here today on the Stout trial, listening to this audio. Did they bring up? Have you been watching that part two, Kono's mom? They're showing some evidence. Let me see if I've got any email updates on that trial yet. Oh, she got me. They're on the third witness for the state right now, she said. Yeah, it's going to go by really quick. I mean, they started at 8 o'clock my time, I think. I think. Yeah, they've been going for what, an hour already? I just don't think they should let that little kid out. He's just going to be a menace to society. He's one of those. He's one of those because since he's been in prison, he's just caused nothing but problems. Hey, good morning, show poodles. Hey, Amanda. He's gotten into fights. He's gotten into physical altercations with the bailiff, not the bailiffs, the guards in the jail. He's like doing little con schemes with some of the other inmates. And I say that inmates, I mean, think about it. He's in there probably, is he in there with, he's only 16. So isn't he in there with people his age? Isn't he in the facility with the younger kids, not the big boys? If anybody knows the answer to that, please help me with that. I wouldn't think he'd be in with older people. I forget what they call that. I'm not awake yet, y'all. I'm still on my, well, second cup of coffee. And I stayed up last night because I couldn't wind down. Do you ever do that? You just can't get winded down? So for those coming on the stream that are going to complain and say the calls didn't or the trial didn't start until like 30 minutes into your video, I'll have to timestamp this video so people don't get annoyed with my talking. He's in big boy jail? Really? He's only 16. Hi, Bama. Good morning. How can they do that? All right, let me check the webinar one more time, guys. It says starting webinar. Oh, am I in the webinar already? And it still says it hasn't started. He's arresting other inmates, even staff working inside the prison. That does not surprise me. That does not surprise me one bit. I'm telling you, he's one of those that there's no remorse. I was watching when I was watching that clip from last night, and her mom, she just kept looking over at him. And I was thinking, because she looked at him for a really long time, and I was thinking, what's going through her head right now? Is it hate? Is it curiosity? What is it? It's so sad. And you can tell it's her dad is sitting behind her because they look just alike. She looks just like her dad. Um, I would have thought weren't they neighbors? So I wonder if they knew him already. I wonder how long they'd all lived in around the neighborhood together. Like if there was some kind of, the parents knew each other and stuff like that. 4:45 this morning, Kona's mom. Oh my goodness, girl. I was better. I was a little bit better than that. I went to bed around 1. But I wanted to go to bed way earlier because I wanted to be, bright and early for you guys today. But y'all don't need my commentary for this. I mean, we're just gonna listen once they start it. I'm just gonna keep checking. I guess if I stay here in this little area where the webinar is, it will connect me as soon as it starts. So it should be starting in about 10 minutes or less. So to give everybody a rundown of yesterday, towards the end of I guess like right after they let the jury go or whoever they had, alternate staying on the jury, people, after they let them go last night, the lawyers were talking about them allowing the audio in and how both of their offices were texting them during the trial or during the jury section yesterday saying, we can hear everything y'all are saying, even when you're, like in your little, even when you're sitting it together at your desk in between each other. And so they both didn't like that. And they had said, "All right, well, the judges will try to figure something out between now and then." So I don't know how that's going to affect today. I couldn't honestly. It says on their thing on their website, you're supposed to follow these rules when it comes to audio in the court. So I put them on mute on y'all's end when they weren't in session, or when they went into like what do they call it, bench meetings or whatever. And so I did what I was supposed to do, but I guess if you left it open, you could hear them talking. But I certainly hope that does not affect anything today. And my dogs are so antsy today too. Gosh, they're gonna drive me crazy. You didn't know anything about the Stauch trial or the Fucci trial, Kona's mom? And you're like a true crime buff, right? How did you miss this one? I just remember the Stauch trial because we were in COVID and they were all over her in the media. Really? So what were you doing during COVID? Were you distracted by something else? I guess, it just depends. I haven't found a whole lot of interest in that ice cream man trial. I don't get the lure of it, so I haven't really been keeping up with it. Oh, Audible. You're an Audible. Yeah. I get on the YouTube rabbit holes and just start going. Find all kinds of stuff. There's a lot of good creators out there that do mini documentaries. Oh, now they're showing the overview map of the neighborhood and where her body was found in the Fucci trial. All right, let's try one more time on the webinar. Let's see if it's started. Still has not started. I guess they're going to start it right at 8 o'clock. I'm sorry, 8:30 their time. I know she was supposed to get sleep and everything else, and she okay. Bama said she's just recently started following this case. I know maybe we'll have to do some panel later today, like during the breaks, because I'm gonna need y'all because I'm gonna be multitasking while we're doing this. Well, Bama, you and Kona's mom should get along great because she talks a lot too. Y'all are just like me. That's why we all three jive so well. We just like to talk. I know. I guess sometimes it's when it comes to little kids, it is more. It's tough. That's why I couldn't do that Dakota documentary. I just that one was rough on me. I couldn't. That little boy was tortured. There's no other way around that. Tortured by someone that was supposed to love him. Dakota Collins. So I couldn't do that one. I'm sorry. I just could not do it. Still hasn't started. And I'm refreshing too to make sure that we don't have an issue with being on the wrong thing. I do want to do one thing really quick while we're waiting. Still has not started, guys. All right. They still have not started it. I just want to make sure I'm not going the wrong way on this. So I've got the sound set on, guys. So as soon as it starts, you'll hear it at the same time I do. Oh no. The dog plays with the skunk. I bet that's horrible. Do you have to what do you wash your dog we talked about this before, I think. What do you wash your dog with to get the skunk sent out? He loves the skunk. Oh, my dog's crying. I gotta move him. What? You like the way I don't know if I've ever smelled a skunk. Dawn and tomato juice and a little peroxide for good measure. So, how does the skunk react to the dog? Obviously, if he sprays him, he's scared of him, right? Your dog doesn't want to hurt the skunk, he just wants to play with him. For anybody that's just watching, or listening and we're not reading the chat, I'm reading chat here. And so apparently Amanda's got a dog with a skunk. Stop ignoring that puppy and give him some love. He's fine. He's okay. He's very he's a little bit of a wussy. He's kind of, I have to he'll be okay. I want to get this started and then I'm going to go take care of him. He'll be fine. He's a big baby. Send Dawn a pic for a lifetime supply of Dawn. You know what? Dawn is awesome for dogs. Like if you have a flea outbreak or something like that, because we've had that happen before, where even though the dogs have, because I lived in Florida for a while, and it gets so hot, and even when you have your dogs on the flea meds and stuff, they still get them, and they bring them into the house. And when you bathe them, if you bathe them with Dawn, it kills them right. It kills them instantly. The Dawn does. I don't know what it is about it, but it's also not harmful for pets. They use it in wildlife, like for all the oil spill cleanups and things. Haas is his name. They don't feel the same way. They're scared of him. That's cute. What kind of dog is he? A keto retriever mix. Oh, really? I I was in dog rescue for a while in Florida, and I had to get out because I didn't know how to say no to the doggies. I had 12 foster dogs at one point, you guys. But I had a cool setup. I had a big room for them and a lot of space. But I couldn't do that now, not where I'm at now. They use skunk in some perfumes. What? I didn't know that. All right, let's see what they're doing. Still waiting. You guys just take your time, really. We're just here. We're just over here waiting on you guys. No big deal. No big deal. And I just checked another main channel that's trying to run it too, and they haven't started theirs either. So it's not just so we're in the right way. We're in the right space. We're where we need to be, but it's just not happening yet. I fostered kittens, Amanda, just because I wanted to just because I was helping with feeding all the strays and stuff at one point because I'd have to get up every morning before I'd go into the office, and I would go around and fill the different trays with water and food for them. Oh my gosh, that was a hard job because it was just there's so many. And then they had a litter of kittens, and I was like, "Oh, I want to help." So I took them home. Kittens are high maintenance. I had no idea. So, yeah, I had them for a little bit, and then, when they got big enough to be adopted out, I took them back to the shelter or the rescue group, and then they were castor oil. You couldn't find the one with the meet the attorneys? It's this the 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 one that I have on all the attorneys and the judges, the little thing, it's actually this is the thumbnail that I've got pulled up right now that you guys are looking at. Let me see something. Yeah, it was posted on March 8th. Yeah, I'll play this until we get. I'll play the audio on it until we get. Carrie with Dimwit Criminals, and we're preparing for the Letecia Stauch trial. And I thought it would be a great idea if I kind of went over some of the players in this trial. We're going to talk about the judge, the prosecutor, and the defense team so we can kind of have a little bit of a background on these guys when the trial starts. So let's start with the judge. Honorable Gregory R. Warner. Judge Gregory R. Warner was appointed to the district court in August of 2006. Judge Warner graduated magna cum laude from the University of Colorado in 1983 with a bachelor's degree in political science. He graduated from the University of Colorado School of Law in 1987, where he also served on the Law Review and published an article. He began practice in Colorado Springs as an associate with a sole general practitioner. In 1990, he began working as an associate for a law firm which emphasized insurance defense. In 92, he became a claim litigation counsel for an insurance carrier with an office in Colorado Springs. He has tried a number of jury trials throughout southeastern Colorado and federal court. He has argued cases in the Colorado Court of Appeals and the Colorado Supreme and the 10th Circuit Court of Appeals. All right, now I found an evaluation on him that's dated 2020. So let me read that for you guys. The 4th Judicial District Judicial Performance Commission voted 7-3 that Judge Gregory R. Warner meets performance standards. Judge Warner has served the community as a district court judge since 2006. The 2020 Judicial Performance Survey Report shows some major areas of concern. The commission acknowledges that since the last evaluation, Judge Warner has had an atypical and difficult caseload, including a death penalty case and additional judicial casework assignments, and has experienced the death of several close family members. Numerous survey respondents noted that Judge Warner maintains an efficient docket and courtroom. The commission's concerns stem from survey responses that indicate Judge Warner's scores are well below the average for all district court judges. Judge Warner's area of weakness include demeanor with a score of 2.9, below the average of 3.5. Ooh, now I can't wait to see how he is. Diligence with a score of 2.9, which is below the average of 3.4. Application and knowledge of the law being fair and impartial to both sides of the case with a score of 2.9, which is below the average of 3.3. And basing decisions on evidence and arguments and issuing consistent sentences both with scores of 2.6, which is below the average of 3.3. Judge Warner also had lower than average scores in case management and communications. Overall, it is the commission's assessment that while Judge Warner runs his courtroom efficiently, he needs to address these areas of concern to avoid being rated as a marginally effective district court judge. Comments such as arrogant, demeaning, inability to listen, and lack of self awareness repeatedly came up to describe Judge Warner and his dealings with those that appear in his court. Ooh. Those comments were countered by positive comments like efficient and fair. After further interviews, observations, and feedback, the commission is convinced that Judge Warner will take the necessary steps to address these shortcomings, and their 7-3 vote reflects this determination. The commission interviewed Judge Warner, observing him in court, reviewed his self evaluation, written opinions, judicial performance data, comments from attorneys and non attorneys, and the judicial performance survey results from 2017 and 2020. It should be noted that a new methodology for the survey, I guess I'm saying that word right, was used this year in which lower response rates may be attributed. So it's affected all the judges across the board and is not an explanation for individual results. The commission also spoke with representatives of the district attorney's office and the public defender's office. Okay, so now let's go on to the DA, the district attorney, Michael J. Allen. Michael J. Allen is a Colorado native and a U.S. Navy veteran. I love it. He enlisted into the Navy after graduating from Arvada West High School and served as an aviation electronics technician. Most recently aboard the USS Carl Vinson until receiving an honorable discharge in 1998. He then earned his undergraduate degree from the University of Northern Colorado and then his law degree from the University of Kansas. Michael began his career as a prosecutor as an intern in the Johnson County, Kansas District Attorney's Office and the Kansas Attorney General's Office and the Douglas County, Kansas District Attorney's Office. Whew, that's a mouthful. He joined the 4th Judicial District Attorney's Office for Teller and El Paso counties in 2011 and has served the Pikes Peak region in several roles. Most rewarding for Michael as serving as the line deputy district attorney managing the Veterans Trauma Court docket. He was able to put his own military experience to use to ensure that the Veterans Trauma Court was focusing its resources in the right cases and defendants that needed and deserved a second chance. At the same time, he knows that violence and career offenders demand our full attention, and he has worked hard to protect public safety. He has been named as the 4th JD's Homicide Prosecutor of the Year in both 2015 and 2017. He is married and has 2 sons. His oldest son teaches high school history and his youngest son serves in the United States Navy. Michael Allen was sworn in as the elected district attorney of Colorado's 4th Judicial District on January 12th, 2021. All right, now let's go down to the defense. Joshua Tolini. Mr. Tolini graduated from the University of Colorado Law School in 1998. He worked in the public defender's office for almost 4 years before leaving to start Barker and Tolini PC. Mr. Tolini has argued domestic violence cases before the Supreme Court of Colorado, litigated and won search and seizure issues against federal drug task forces, and successfully defended several high-profile homicide cases. His areas of practice are criminal law, domestic violence, homicide cases, domestic violence and negligence, drug violations, and sex offenses. All right. Now, his partner in crime on this case is going to be Will Cook. Why choose Will Cook? Will Cook should be your attorney because he has a potent, this is from his website, you guys. Will Cook should be your attorney because he has a potent mix of experience, savvy, and compassion. Will started his legal career at the Public Defender's Office in Memphis, Tennessee, and later worked as a prosecutor in Colorado Springs. He also worked for the federal government in the United States Department of the Interior. Through that experience, he learned the ins and outs of how a prosecutor puts a case together. He earned a reputation as an excellent trial attorney. In private practice, Will continued to hone his skills as a trial attorney and continues to perfect his craft. Knowing the ins and outs of the prosecution's case allows him to dissect it as few other attorneys can. Other attorneys marvel at his ability, really, to persuade a jury to have compassion for his clients. Will has prevailed in every type of criminal case with his unique combination of smarts, common sense, and persuasion. Call it Southern charm or call it compassion and credibility. Will works hard to allow juries to see the human side of his client, to focus on the facts and disputes, and to acquit. You may find attorneys with cleaner desks, but you won't find an attorney over whose desk has passed more difficult cases. Will listens, Will investigates, and then Will puts that information together to give his clients powerful themes to negotiate or litigate a way out of the criminal justice system. Give Will a chance to earn his seat at the criminal defense table. Call, text, or email him today. Sounds desperate. Okay, so anyway, those are the players. And of course, we know the main player in all of this is Miss Stauch herself. Er,
And do you know approximately when this was posted?
It would be in the timestamp. So it would be on the 9th of May at approximately 4:52 p.m.
And then I'm just going to play the next two videos that you received from Snapchat of interest.
Fun in a fucking cop car. Yep. Tristan, what's up, guys? Yep. Tristan, if you fucking walk out the damn. When you see this in a month, having fun in a fucking cop car. Yep. Tristan, what's up, guys? Yep. Tristan, if you fucking walk out the damn. When you see this in a month,
then I'm going to play the next one.
Car, guys. Tripping, dude. It's in a fucking cop car, guys. Tripping, dude.
When you review the records, Snapchat indicates these file names are under memories. What is that? Does that mean it's something that the public can see, or he directly sent to like one individual?
No, that basically it's your homepage, if you will, your the snaps that you post. They're posted to your memories, and basically everybody can see those that you're friends with.
All right, so you're advised that that sort of thing is going on, asked that his phone be taken. At this time, are there detectives tasked with searching for video based on the information you had from Trey and Aiden at this point?
Yes.
Okay. What information, kind of what area of the neighborhood were they focusing on that time for video based on what you knew?
Based on the initial information that they obtained from Trey and from Aiden, is that Aiden and Tristan had left from Trey's house at about 1 a.m. and were walking north along Durban Parkway, and they mentioned the amenity center. So we went to the amenity center to look for video there.
Okay. And what did you learn from the amenity center video?
There were two subjects that were seen walking past the amenity center, I believe, at approximately 1:24 a.m., which was consistent with the direction and time frame.
As the investigation continues on that day, when was Tristan's body alerted to your agency that it was discovered?
The sheriff's office received a phone call from a subject named Daniel Hart, who advised at 6:06 p.m., who advised that he had been out in a wooded area and found a deceased body at that point.
What happens with the investigation at that point, and specifically, what is your role?
At that point, it transitions into a homicide investigation, and I was designated as the case agent.
Do you go out to the crime scene at that point in the woods, or what do you do?
I did not. Crime scene technician Marilyn Butts was tasked to go out to the scene where she was located to process that scene and collect evidence, and then I was kind of gathering information and looking at what the next steps were in the investigation.
Do you proceed to write a series of search warrants for various residences and places?
Yes, we began to secure several different residences to either obtain consent to search from the homeowner or to draft search warrants.
And based on the location now of Tristan's body, are there detectives that are dispatched to that area to search for video?
Yes.
Okay. And sort of throughout the night, where do you end up stationed, where you're drafting warrants and things like that?
I'm at the Northwest Field Office.
Okay. As information comes in from video that's being located, is that relayed to you?
Yes.
Okay. As you're working on warrants and afterwards, what information of importance becomes available from surveillance in the Saddlestone Drive area?
We first got video, I believe, at approximately 7:54 p.m. from a residence at 541 Saddlestone Drive. On that video, it depicted two subjects walking east past the residence in the direction of the cul-de-sac on Saddlestone Drive. One subject appeared to be taller, and this was at the video captured then at 1:45 a.m. One subject appeared to be taller and could be seen wearing a pair of white shoes with a black Nike swoosh. The next video was at 3:27 a.m. and there was only one subject that was seen walking west away from the cul-de-sac.
That same subject that was previously wearing shoes?
Yes, and at 3:27, it was appeared to be the taller subject who was previously wearing the shoes. Now the subject appeared to be carrying the shoes in his hand.
And later that night, approximately an hour later, did detectives locate more video from Saddlestone that was helpful?
Yes, we located video at 586 Saddlestone Drive, which for reference is in the direction of the cul-de-sac from the first residence, 541. On this video, there were two subjects observed walking east towards the cul-de-sac at 1:46 a.m. and they appeared to be, excuse me, the same two subjects. And then the next video shows one subject appearing to be the taller subject from the first video as well. The subject was running west away from the cul-de-sac at approximately 3:27 a.m. And you could see that in the video that he was carrying something in his hands.
You're finding that information out. Warrants are being executed. Where was the defendant ultimately brought and put at your agency?
He was transported to our Central Investigations Division and placed in an audio and video recorded room, and his parents were allowed to be in there with him.
Was your agency able to, did you attempt and were you able to get into Aiden Fucci's phone that night?
We obtained a search warrant to do a forensic download of his phone. However, Detective Causey, who was our digital forensics detective at that point in time, advised that due to the technical constraints of the phone, we weren't able to actually get a download from it. So we weren't able to get a download that night.
Okay. And the court has heard about the processing of 724 Castledale and the items of evidence that were removed from that room. You were advised of those items, the shoes,
yeah.
Sure. Go ahead and just describe what you were made aware of from.
I was advised there.
Okay, let me share the screen because I don't want to miss anything on this trial.
Blood.
Right now, they've got it on
a pair
mute.
of wet jeans that we obtained from the laundry hamper.
I think that what they're going to end up doing today is muting us a lot. Oh, I'd mute us too, I guess. No, I think after that discussion that they had yesterday, thank you so much, Kona's mom, for that super sticker. You're so sweet. You're awesome. I think they're going to mute a lot today. After that discussion that they had last night. The judge is currently muted, which means they're probably talking. They may be even not letting us listen to the discussion between the attorneys and the judge, and they're just waiting until they bring in more jurors, and then when they start doing the juror thing, then they'll take us off mute. That's the only thing I can figure. But we don't want to miss it, so. That's what the silence is all about. I can unmute the Fucci thing and we
A
get
sharp
it.
force weapon and what efforts were made?
Yes. Approximately noon, our field force teams and our dive teams deployed to the wood area that Tristan was located in attempts to locate items of evidence. Our field force team searched the wooded area and our dive team searched 2 ponds in that area.
Okay. Were you present for all or part of that search effort?
Yes, after I attended autopsy, after that concluded, I joined the search efforts that were in progress still.
And was that search effort successful in recovering evidence?
It was at approximately 6:30 p.m. A dive team member located a folding buck brand knife in the pond. The knife appeared to have the tip of the knife was bent, and the very edge of it was broken or fractured off.
Were you present when that knife was recovered?
I was.
Without objection, state would move in states E and permission to publish.
No objection. No objection. That'll be received as states number 6.
Can you guys hear the The Fucci trial in the background?
Okay. 6A is just an aerial of the general area that was searched by the dive team. Is that correct?
Yes, ma'am.
Okay. And
Hey,
states
Miss Barbara.
6B and C show that area of the retention pond closest to where Tristan's body was located. If you kind of could just describe who's seen in this video and anything of note in this video, or photograph, excuse me.
So you're looking at from the first photo from A, you're looking at the larger of the ponds. This is looking in more of a southern direction. And you see the house on the right, that's where the cul-de-sac of Saddlestone Drive is. So the diver that's in the water is Deputy Todd Willis of the Sheriff's Office, a member of the dive team.
Okay.
All right. Court will call 20 CR 1358,
in
People
the,
versus Letecia
approximate
Stauch.
area, or
Record
does he
should
have
reflect the
marked
jury.
where he recovers the
The
knife?
jurors
Yes.
are present in the
And,
courtroom. Good morning, ladies and gentlemen.
Describe it and or.
Oh, come on. It's the second day of spring, right? Let's try again. Good morning, ladies and gentlemen. My name is Greg Warner. I'm a district court judge for the 4th Judicial District. Before we begin the jury selection process, I'd like to introduce you to some of the people who are in the courtroom and who you may or may not have already met. Kathy is my court reporter. She's not going to wave because her fingers are doing something else. It's her responsibility to make sure that everything that is said in the courtroom is transcribed into what we refer to as a record of the proceedings, so that anything that is said by you, the lawyers or the witnesses, is made part of the record. Remember, she can only take down what you say. Nods of the head and uh-huhs and uh-uhs don't get translated very well either. So if you can give us a verbal response, it will make her job a whole lot easier. You've also met Mr. Sproul and Mr. Combs. They are here to assist you. You can talk to them regarding any general matters such as parking, phone calls, those sorts of things. However, do not talk to them about this case, and they will not talk to you about the case. They're not being unfriendly. It's just that they are not permitted to discuss anything about the case with you. I assume that many, if not all of you, were not excited when you received your invitation to come down and join us. But please understand how important you being here is to our judicial system. I want to thank you for being here. You should know that the United States conducts approximately 90% of the world's jury trials. Many other countries do not trust their citizens to make these kinds of decisions and leaves those decisions to be made by some member of the government. However, when our country was formed, the people who formed our country believed that the government should not have that much power. As a result, they placed in our federal constitution and our state constitution has a similar provision for a right to a jury trial. That right cannot be secured unless all of us have the obligation to serve when called. In case you're wondering, yes, I have that same obligation. Yes, I've been sitting in the same seats that you're sitting in. I understand that it is a sacrifice for you to be here and put your lives on hold, and I deeply appreciate your participation in this process. Thomas Jefferson said, I consider trial by jury is the only anchor ever yet imagined by man by which a government can be held to the principles of its constitution. I've spoken to hundreds of jurors over the years. They all told me that they were glad that they had served. They said that they had learned a lot about our judicial process and how important that citizens such as yourself are to it. My hope is that if you are selected to be on this jury, you have those same feelings at the end of the trial. I do want to remind you at this point in time that you can't use your cell phones at any point during this process. So if you can turn those off, you need a moment to turn off your cell phones, go ahead and do that. In addition, we are identifying you by a number in court rather than the name. So we're going to be identifying you by seat number. We do that for a couple of reasons. First of all, Due to the number of jurors being called, we do not want there to be any confusion regarding who we're referring to at any point in time. There may be one, more than one Mr. Martinez or more than one Mrs. Smith. By referring to you by number, we keep that separated, and it's clear in the record who we're talking to. In addition, while the defendant, the attorneys, the staff, and myself will know your name, referring to you by number is to protect you from contact by the media or other persons, curiosity seekers, and the like, to protect you from unwanted publicity, and to ensure that no outside information is communicated about you through the process of this trial. Finally, after talking with a lot of jurors over the years, they all told me that they were more comfortable when referred to by a number as opposed to a name. The fact that we are identifying you by number should have no impact at all on the presumption of innocence that the defendant is entitled to, or any impact in any other way as you consider and decide this case if you are selected. The case we are about to try is a criminal case. The prosecution is brought in the name of the people of the state of Colorado. The prosecution in this trial is represented by Michael Allen, Dave Young, and Angelina Gratiano, who are lawyers with the district attorney's office. If you would stand and
Morning.
I will sometimes refer to the district attorney as the prosecution or the people. The defendant or the accused in this case is Letecia Stauch, and she is being represented by Josh Tellini and Will Cook. The charge against the defendant is contained in what is called the information and complaint. An information and complaint simply describes the charge made by the prosecution against the defendant. It is not evidence of anything. In this case, Ms. Stauch is charged with murder in the first degree, child abuse resulting in death, tampering with the deceased human body, and tampering with physical evidence. To these charges, Ms. Stauch has pled not guilty by reason of insanity. Therefore, the prosecution has the burden of proving the charges beyond a reasonable doubt. The jury will decide whether the prosecution has proven beyond a reasonable doubt that the defendant has done the things that are contained in the information and complaint. In this case, as in all cases in Colorado, the jury will be only determining the facts in the case. They will not be determining the punishment or sentence. This is not a death penalty case where a jury has to determine whether that should be imposed. This is just a case where the jury is determining the facts of the case and whether or not the prosecution has proven everything that they're required to prove beyond a reasonable doubt. If I can have all of you stand and raise your right hand, please. Do you and each of you solemnly swear or affirm under penalty of law to answer truthfully the questions asked by the court or counsel concerning your service as a juror in this case? Go ahead and have a seat. Thank you. Before we go any further, does anyone have any difficulty either hearing or seeing what's going on in the courtroom? All right. 1, 2, 3, 4, 5. Juror number 5, or I'm sorry, 6. Juror number 6, you would raise your hand. Yes, ma'am. Okay, can you see me okay? Oh, you moved around a little bit. You did a little bit of bobbing and weaving. Okay, but are you able to see the attorneys in the counsel table okay?
Yes.
And my court reporter, can you see her all right? So this would be an issue if you were a juror and there were an exhibit, say, up on this screen or that screen, depending, you might have some difficulty. Okay. All right. Anyone else have any difficulty either hearing or seeing what's going on? No. All right. And before we go any further, I want everybody to understand if you are in this courtroom, you should anticipate being on this jury. And we're going to be asking questions of everybody in the courtroom as opposed to just the people in the box. That's important to understand because I bet everybody back here when they came in was going, I am really glad I'm not sitting up there. But you need to understand that we always get into the back rows. We did yesterday. I anticipate that we will again today. And we'll go through that process a little bit further. In this case, we're going to select 12 jurors and 6 alternates. They will consider all the evidence produced during the trial, and they will determine what the facts are based on this evidence. The attorneys anticipate that the case will take 6 weeks for trial. That does not include deliberations or jury selection. We hope to start the presentation of evidence on April 3, so that would mean finishing evidence sometime in mid to late May. I do understand the burden such a lengthy trial places on people. I previously presided over a case that took 18 weeks from start to finish, so I understand the burden. I've been there. I get it. Our trial days will generally be from 9 to 5 on Monday, Tuesday, Wednesday, and Friday. There will not be any trial on Thursdays, as I have other docket matters that I have to attend to. You will be able to go home to your families each day, and though you will not be able to discuss anything about this case with them, you will be able to talk with them about anything else. Knowing this time commitment, is there anyone who believes that they would suffer an undue or extreme hardship if required to serve for this length of trial? All right. And I'm going to start in groups. So I'll start over here first. Juror number 4. Tell me what's going on.
Who has dementia in Washington State
I'm sorry, ma'am.
every 6 to 8 weeks to taking care.
Okay. I'm sorry for your loss, ma'am. When did that happen?
He died in November.
Okay.
I've already been there. I was there. That's why I postponed my jury. Now,
Okay.
because I was there for a month.
Okay.
I'm leaving again May 4th.
Okay.
And I'm also on another, I'm subpoenaed for another on May 1st.
That doesn't sound quite right here, because you shouldn't be subpoenaed for 2 of them that close together here, unless, are they both here and at the El Paso County Combined Courts?
I think she's saying subpoena judge, not summons.
Oh, I got it. Okay, yes, all right.
Subpoenaed
Okay, all right.
May 1st, and they said it should only be 1 day.
Right,
Like I said,
okay,
we have plans to leave.
okay, all right,
And I could be gone for a month.
okay, all right. There was another hand in the back, juror number 6. Yes, ma'am?
I can't drive, and it would take a lot to have somebody drive me to and from court every day.
Where do you live?
Near Pat's Peak and Murray.
Okay. We might be able to do something about that. I have in other cases, not for a trial that's been this long, but I will take that into consideration. Anyone else? Let's see, that would be juror number 8.
Yep, self-employed, startup, so we're still in our early days. All my time is necessary to help run the business.
What kind of business is it? Consulting what?
Technology.
Oh. Anyone in juror number 10? What kind of work do you do? Do you work for a company? And would that company have the ability to fill in your spot with someone else? Front row. Juror number 12.
We have an extended family vacation scheduled for the middle of April, and we've prepaid for a pretty big portion of it. So
Okay. Anyone, let's see. 15, juror 15? That would be you, yes. It's okay.
Yeah, I'm the primary caretaker of my son. There won't be anybody to drop him off at school or pick him up from school during the time that would be needed for.
How old is he?
He's 8.
What time is he dropped off at school?
I drop him off 7:30. And then he has to be picked up a little bit after 2.
Okay, the drop off wouldn't interfere with being able to be here. Would he?
8 o'clock that we would need to be here, or 9?
Pardon?
Is it 8 that we would need to be here?
Generally about 9 o'clock.
So
Sometimes,
picking him up.
okay. And do you have anybody else that would be able to pick him up if you're not able to?
No, we're not from Colorado. We moved from New York. It's just myself and my husband. That's
Okay.
it. I have no one else.
Okay. Anyone else in this front row? No. Back here, this front row? Juror 21 on the end there?
Sole provider for the house.
And what kind of work do you do?
So right now I'm getting ready to go back into the work field.
Okay. Others in the front row? Let's see. Juror number 25? No, in the front row here. Juror 25? Yes, ma'am, you. When? That's a Monday. Where is the service going to be? No, I understand that. All right, and the second row, starting at the end there, that'd be juror number 35. Go ahead. How old is your husband? Okay, all right, thank you, ma'am. Anyone else in that row? Juror 37? Okay, that's at the start of June. Okay. I think we'll be done by then. Pretty sure we should be done by then. Tell me, and did I understand you correctly when you said that you work, but you don't think that the work would be an issue? Okay. Right. Okay. Thank you, sir. I thought I had another hand back there. That would be juror number 38. Yes, sir. Juror number 40, did you? Yeah.
Vacation, pay overseas.
You said mid-May. Do you know when the start date would be? Okay. All right. Thank you. And juror 41, did you have your hand up?
I just work, but that's nothing out of the ordinary for anyone else.
Okay. Anybody in the far back row? I'm going to start over there on the end, juror 49.
A power at home that is 37. Right. Our life. Husband works full time. I don't work. I take care of her.
Okay. All right. And next, juror 50. Do you, is it local? Yeah, no, it's, we for sure will not be having, any trials on Thursdays, and that is a Thursday, so that's going to work out okay? Okay. All right, juror 51, did you, yes? Hold on, when you bend over and talk to the floor, I can't hear you, so. Well, we go by seat number here. So it's okay, that's all right. Because we have to have both of those. See, we're selecting a jury over a period of days. And so we have your juror number, which is the summons number. But when you come in here, we're referring to you by seat number. Okay, so you would be juror 51. What do you have to tell me? What kind of work do you do? And is that like a massage therapist, a psychology therapist? What kind of work? Okay, all right. Anyone else in that back row? Okay. Looks like juror 53. Okay. You said May 15, right? All right, and juror 54.
Yes, sir. My wife's finally ill. She's had to have a number of sudden surgery.
And juror number 55. Yes, sir.
So, Your Honor, I just got off a 12-hour shift. We lost about 50% of our staffing outside. Where is open for left over. If I leave here today, have to go back to work tonight. basically everybody's on 12-hour shifts and working their day, they're all their days off, 2 days off.
What kind,
They get that duration of the file.
what kind of work is it? All right, and up here in this first row, juror 30.
Mr. Owner, I am still.
All right, so another hand up here. Okay, juror 33.
Also work 12-hour night shift.
What kind of work do you do?
I do work some weekends. Want to go and work on weekends.
Okay. All right, juror 34. All right, and second row, juror 43. That's you, ma'am, in the stripe. That's okay.
Starting supervisor classes for my job and a couple of weeks.
I'm sorry, I didn't understand anything that you just said there. Can you do it again?
So I'll be taking management classes and about so I'll probably last for
The beginning of May. Okay, what kind of work do you do? And can those management classes be rescheduled to a later time? Okay, can you check on that during the lunch hour? Okay. I still want you to check, okay? All right, and I thought there was a hand. Yes, juror 44. Okay. All right, as far as diabetic is concerned, we've had diabetics before on the jury, and I've been able to accommodate that without issue. When is the trip in May? Okay. Anyone else in that second row? Okay, let's see. Juror 47. Right, and in the next row back there, and this is sort of where I have to stand up so that I can make sure I see correctly. All right, let's see. Juror 58. Yes, ma'am. And juror 59. Did you say over the weekend? Oh, I'm gonna say, I thought you were going overseas over the weekend, and I was going, that's a really quick turnaround there. Okay, anyone else in that? All right, and that would be jurors 62. Yes, sir. 24th. Okay. And where are you going? Anyone else in that row? No. All right. Next row back. Okay. Wrong sheet. Juror 66 over here on the end. Yes. The gentleman there that just barely has his hand up. Oh, I'm sorry, I didn't see your hand. Okay, so let's try again. Yes, okay, juror 66. Yes, sir. Got it. Okay, and what kind of job is it? All right, and then juror 67.
I didn't think it was a problem with having a team card and
Okay. Juror 68, did you have your hand up? Yes, sir. Well, wait, I'm confused. Where do you live? Okay. Okay. And juror 69, did you have your hand up? Yes, ma'am. Okay, I was having a little bit of hard time understanding you. Have a doctor's appointments in New Mexico?
Yes. I have broke my wrist.
Okay.
Help me out.
Okay. And in the far back row, juror number 70? On the end there? Yes, ma'am.
I'm a paralegal and my husband. And I am on his office manager. Actual attorney. That's definitely.
All right. And juror number 71. How do you get there?
Well, I don't have time to.
And anyone else in the back? Looks like juror number 74. Yes, ma'am. Juror 74.
You know, you can imagine that this judge hears all kinds of excuses during these. Best excuses, that'd be a great little thing to do. Best excuses ever heard by a judge for jury selection.
Okay. All right. Is there anyone that there was one that I missed, and that would be juror 73. Go ahead. Well, you should be okay with either one of those because you're probably not going to be here tomorrow. The jury selection is today. We don't start evidence until April 3. And if your other appointment is next week, that will occur before the evidence starts. Okay. All right. Is there anyone that I missed? Juror number 36 over here.
Vacation.
And okay, thank you. And then juror number 68. No. And I'm glad that you brought it up. Here's what's going to happen. We're going to take a break at about 10:15 or so. So we'll have a restroom break in about a half an hour. Is that going to work? Okay. So we will take a break this morning, but I need to have everybody in the courtroom to be able to hear everything that's going on while we're all here. Okay. So we will take a restroom break if it's something urgent, if something comes up or something like that. Let me know and we'll see what we can do about taking a break that is not scheduled. Okay. Are you going to be okay until about 10:15? Okay. 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 Well, all right. All right. Let's see. I need to go through some challenges for cause, or I need to ask some questions regarding things that may disqualify you from serving as a juror in this case. I want to go through that list of grounds now. Do any of you believe you are related to the defendant or any of the attorneys? No response. Do any of you have a relationship of guardian and ward, employer and employee, landlord and tenant, debtor and creditor, or principal and agent to, or are you a member of the household of or partner in business with or surety on any bond or obligation for the defendant? That's a long lawyer question asking if you have particular relationships with the defendant. Do you work with them? Do you work for her? Does she work for you? Do you rent from her? Does she rent from you? Any of those kinds of things. So we're looking for particular relationships. Anybody think they fit in that category? No response. Are you now or have you been a party in a civil lawsuit involving the defendant or have complained against or been accused by him, by her in a criminal prosecution? Anyone think they're in that category? No response. Were any of you a witness to any matter related to the crime or its prosecution? If any of you believe that you are a witness in this case, please raise your hand. No response. Do any of you have a personal or financial interest in the outcome of this case? Anyone feel that? No response. Do any of you have any feelings or a bias for or against the defendant or the prosecution? Juror 21. Okay. And I was going to ask about that, and there actually was a question about that on the questionnaire. Did you take part in any of the vigils or the searches or anything like that? You did. Okay. Yes, sir. Anyone else? That would be, hold on a minute. Let's see, 1, 2, 3. That would be juror 58. Yes, ma'am. Okay, and that's a little bit separate question that we'll ask about later. Whether or not you have any preconceived notions or anything like that. So either I or the attorneys at some point, like, we'll be asking about whether anybody has psychology training, those sorts of things. And that's where we will want to talk about it there. What I'm asking more about is feelings about this particular case. It sounds like you have experience in the area that may impact your thought processes, but you don't have anything specific to this case. Is that right? Okay. Anyone else? No response. Public law enforcement agency or the public defender's office? Please raise your hand. No response. Please raise your hand if you are not a citizen of the United States, are not at least 18 years old, nor a resident of this county. Anyone in that category? No response. Please raise your hand if you are unable to read, speak, or understand the English language. Anyone think they're in that category? No response. Please raise your hand if you are incapable due to physical or mental limitations to render satisfactory jury service. Anyone think they're in that category?
Please, sir.
Yes. Please raise your hand if you are incapable due to physical or mental limitations to render satisfactory jury service. And that would be juror number 20. Yes, ma'am. What's your concern?
Well, mentally, my mind is made up. No insanity. If it's a hung jury, no insanity. I cannot be moved. When I was very young, my adopted mother took butcher knife to me. as a way of getting me to do what she wanted.
Okay.
So I don't know if that goes into this or a different question.
Well, that's a slightly different question, because that would be a bias or something of that nature. What we're looking for here is whether or not you have a physical or mental limitation. Perhaps you're on a medication that you have to, you're not able to stay awake or something of that nature. The concern that you have is a legitimate one. But what we're looking for here is if there is, the physical limitations are easy. Some people say, I can't sit for very long, or I can't move, or something like that. So we're looking for something like that in the mental limitation. It sounds to me like because of a past experience that you have certain feelings about this case. And that's a little bit different. It's still important, and that's something that we need to know. So I'm glad that you brought it up. But it sounds as though you're able to hear me okay, able to see okay, able to process information. I've occasionally had some people that say because of the medication that they're on or something like that, they can see things, but they can't process stuff very well, or it will affect their hearing such that they can't hear very well, those kinds of things. That's not your issue. Your issue is a personal experience. Do I have that right?
Yeah.
Okay. Please raise your hand if you have the sole responsibility for the daily care of a permanently disabled person living in your household such that your service would create a substantial risk of injury to the health of that disabled person. Anyone think they're in that category? And Juror 35, you already told us, is there anything? Okay, I understand. Please raise your hand if you have served for 5 days or more as a trial or grand juror in any state or federal court within the past 12 months. Anyone in that category? No response. At this point in time, we're going to have my staff is going to hand out a list of witnesses. The question that I have for you is, do any of you think you know any of the potential witnesses on this list? All right, are you going to be okay back there? Okay. 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 All right. All right. Here's what we're going to do so that everybody understands. We're going to take about a 15-minute recess now. When we come back, we're going to be here until noon. Okay, so let's hold off on, let's recollect those witness lists for right now. And I know that this is different than what you may experience in a lot of other situations, but I cannot proceed. We cannot proceed with this questioning and proceed with talking with everybody here unless everybody is here. And everybody has to be here at the same time. So if you need a break, take it now. So we're going to take our break until 10:15. When we come back, expect to be here in your seat until noon. All rise for the jury, please.
Can we go out this door?
No,
Oh, okay.
no, that's a secured hallway. So it's gotta be that way.
Okay, thank you.
Well, there you have it. Sounds like he's no nonsense. I really like that about this judge. He's like, okay, look, if you got to pee, we'll go ahead and, we'll put you on. We'll take the break now. But damn it, I wanted to wait to take the break, but we'll go ahead and take it now. Charnel says, I was just in a stint on the grand jury at a young age. that captured my heart and built those neurosynapses for the law. It's really interesting that I've learned just in like doing true crime on YouTube in the short time that I've been on here. It's just so interesting, all the stuff that you learn. I think that's why we're all drawn to it, huh? He does seem like a good judge. I like him. If I take off the volume in the Fucci trial, I think you're on mute right now. See, it's hard for me to click over and change over to the Fucci trial and then click back over to the judge trial. So I don't want to like bring that up, but I'm going to turn on the audio for you guys.
He asked a question about the mental capacity, the drugs I'm taking, and I mentioned seeing a neurologist tomorrow. She's going to give me the results of an MRI of my
To go out of
Leave it, I'll
the
get to that.
courtroom.
Oh, okay. I'll just let it sit there for a minute.
So it looks like juror number 73 is going to be gone. He has some major medical stuff. And I muted it because I didn't know if that should be aired or not. But I think they're going to dismiss him. Bless his heart. Y'all talking about the chocolate pie again? Using Minnie's recipe, no doubt. Love it.
Record should reflect the jury has left the courtroom. And Ms. Stauch, I think you have seen the circumstance that we have to deal with. So instead of taking a later break today like we did yesterday, it's now. Do you need to use the restroom now? Or are you going to? Okay.
Gosh, I hate that we can't see what's going on. She has some of the best facial expressions, and we're going to miss all that. Two Slice Hilly. Y'all are funny. Well, I thought they were going to come back on and do some more talking, but it doesn't sound like it. Let me see if there's any audio on the Fucci trial right now. Oh, there is. They got somebody up on the.
Normally, we talk a lot about DNA in a trial setting. I don't think that's necessary here. So let me just ask you, ma'am, in May and June of May of 2021, were you assigned to conduct DNA testing on a number of items of evidence from an investigation by the St. Johns County Sheriff's Office that was in connection with a victim by the name of Tristan Bailey?
Yes.
All right, I want to ask you about some of the items specifically of evidence that you received. Did you receive DNA standards that were identified as coming from Tristan Bailey as well as Aiden Fucci?
Yes.
And did you conduct DNA testing on those items?
Yes, I did.
And were you able to develop profiles of both Tristan Bailey and Aiden Fucci?
Yes.
Did you also receive an item that was identified as a white American Eagle t-shirt?
Yes.
All right. And did you conduct DNA testing on that item?
Yes, I did.
All right. Was there anything unusual about the shirt itself, something that kind of focused your attention in terms of DNA testing?
I was looking at reddish brown staining, tested positive for blood.
Okay. And where were those reddish brown stains located that you tested?
They were on the front and back of the shirt.
Did you do anything to determine whether or not those reddish brown stains were actually blood?
Yes, I used the chemical color change test, and all of the stains I took for DNA testing did give chemical indications for blood.
And what did you do next?
I took cuttings of the stains and I took a wearer sample from the back of the shirt, and those samples went forward for DNA testing.
And you, if I understand correctly, you tested 4 areas of the shirt, including the that you tested for wearer DNA. Is that right?
Crafts, do you want to come up real quick and give us a his team was stupid all morning. Do you want to come up really quick and give us a rundown? Let me drop the link. She's gonna tell us a little bit about what went on with the Fucci trial this morning. We were actually watching a little bit of it because they didn't start this webinar for the Stauch trial until really late. Okay, I just dropped the link. What you're going to do is you're going to click it. You're going to need to turn the audio off on your YouTube, on your whatever you're watching it on your phone, or because if you don't, you'll have echo. And you can turn your camera off as well if you don't want to be on camera. That's one thing I like about StreamYard is it's pretty easy for someone to jump on. Just a few little things here and there, but it's not as bad as some sites are. There she is. Hello, girl. Uh-oh. We have a robotic delay. We can't hear you that well.
Oh Lord. Well, hold
Oh,
on.
no. That's better. That's better. Okay, I'm going to shut up. Tell us what you learned today in the Fucci trial.
Okay, so we started the morning, and at first they were talking to Deputy Malone, who was the one that answered the 911 call, and how he went to Trey's residence. I guess that's where Aiden and Tristan were hanging out. And then he found out that Trey's address, went over there, talked to the teens, got the camera footage from that house. Then they went to Aiden's address, got camera footage from his house. When they appeared at Aiden's house, they talked to Aiden on the front porch with his stepfather, took Aiden on the road with the stepfather following in a golf cart.
Huh. Weird.
And then they literally drove the path he said they walked.
I have a good question. Are Aiden's mother and his stepfather in behind him in the
No.
Nobody's behind him again?
Nope. So, and then their second state witness was the forensic unit lady, Marilyn Butt, and she is the one that took the pictures from the cul-de-sac all the way back into the woods where Tristan was found.
Mm-hmm.
The pictures of Tristan before they touched her. She also was there when I can't think of the name. The mortuary came and picked her up and all that. She was there for all that removal.
Okay.
They did a lot of exhibits with her as far as it was States Exhibit 3 and it was A through K with all her pictures.
Did they show autopsy? They didn't show.
These are the pictures of the walk down the woods,
okay,
the fence, the pond. So they stopped all that. They tried Aiden's attorney tried to argue the pictures not to be shown. The judge overruled, so they showed all those pictures. Then they started with State's Exhibit 4, which was the search warrant. And then the pictures of the front of Aiden's house, right when you walk in the front door, up the stairs, the common area up on top of the stairs, Aiden's door, and then they open the door, and then the picture of looking into Aiden's room, and then literally pictures of different sections of his room.
Mm.
And that is where they had found in his closet, he had a long dresser. Between the dresser and the wall is where he hid his Nike shoes that were full of her blood.
Oh.
When they removed the dresser, they found the white t-shirt he was wearing with her blood.
Hmm.
And then the laundry basket, they found his jeans with her blood.
Did they say anything about, well, I guess they're not going to talk about the day, but the mom, she was brought in because they caught her trying to launder his clothes, right? To cover up the crime?
They haven't talked about it yet, but yes, she did.
I wonder what happened with that part. If she got in any trouble, like what kind of trouble she got into.
Well, I don't know if that's going to happen after this or if that might be part of his pleading where she gets out of trouble.
Yeah, so like he pled so that she wouldn't get into trouble.
Yeah.
Yeah.
So the third person they brought on the stand was the Sergeant Kirk. And he was sergeant on patrol that day. And he was alerted at 2:33 p.m. to show up for the criminal investigation from the 911 cops so they could start the whole federal or the whole investigation part. And then they showed number 5 of the state's evidence, which was the Snapchat.
Oh, yeah.
So they showed all that.
If you guys ever heard of, they refer to this in the media, because the media always like to put some big title on it so that it becomes, viral. They refer to it as the Snapchat murders. I'm sorry, the Snapchat unaliving. Oops.
Yeah. We call it murk. So the rest of that was the search warrant for his phone, his residence. That was all under that cop. And then they also brought in a drone and that was state number 6, A through G, which was the aerial view of the large pond. The zoomed in where he was on the edge of the pond. They found the knife from a swimmer. They went down and got the knife, found the knife. Knife had blood on its blade and on the keel of the knife.
He wasn't a very smart criminal, was he?
No. And the fact that he left a piece of the knife in her head.
Oh, no. Oh. All right. So they're supposed to be speaking with some teachers later today because I think he's going to allow them to listen in on how he was in school. Like this kid apparently has. What?
Yeah, he did allow it. He is allowing it.
Yeah. So I think, because I think that's important to see. This kid apparently has been a thug his whole life.
From what I understand, since 4th grade.
Yeah. So the judge does need to take that into consideration because, I mean, it's obvious. I think a lot of people would agree with me. This kid doesn't need to be let out. He needs to be in jail. No. He's going to commit another crime if he gets put. He's one of those. There's no remorse. He doesn't seem to be affected at all. He's just become more of a bully since he got into the jail.
Well, then they're bringing that in too. The judge is going to allow that in too.
Good. Good.
From him bullying for commissary stuff. Everything he's done in jail is also going to come in. But they literally from 8:00 p.m. on the 8th all the way till 3:22 p.m. on the 9th, have video from the neighborhood, videos of Aiden walking with Zophie, which was his girlfriend. They went to Zophie's house. Aiden left there, went back to Trey's, and then Tristan showed up at Trey's, and then Tristan and Aiden left, was walking together, and then disappeared for a little bit, and then all of a sudden, 2 hours later, Aiden shows up running with his shoes in hand.
Yep, that's the video that they had all over the media. I remember that. All right, well,
So,
I think they're fixing to come back on to into court. You still have a lot more, Rebecca?
yeah, the next part is literally the forensic stuff, so I'll do that later.
Yeah, we're gonna have time at lunch to kind of continue, I guess, through that. Well, you're
Okay.
awesome for staying on this. Are you guys on lunch break right now, or are you on a break?
Yeah, we're on lunch
Okay. Well, it
because
might
we're
be
on
hard.
Eastern, so.
Well, if you want to, it's up to you. If you want to email me some, because you did send some type of report, and I did report on that this morning. I don't know if I responded back to you yet on email, but I did let everybody know in chat or before the other trial started what was going on. So
Yeah.
All right. Well, sounds good. Thank you so much for your help and you're staying
No
on that.
problem.
You guys send her some love.
Bye, y'all. You have a good one.
For where you are before you go, because we honor the third grade seating chart here. And I didn't do that, and that's my fault, and I'm sorry for that. So if it is causing some confusion as to where some people should be, I think we're still missing a juror. We are right. We're missing number 5. I'm sorry.
Number 5 took off.
Yeah, I told him not to worry about it.
I think they did just say that 73 was gone, y'all. That's the person who has medical issues.
All right. I think we have almost everybody. We're missing one, but that juror was going to be excused in any event. So I have taken the time to look through, or I've used the time to look through the juror list, and I'm going to excuse the following jurors at this point in time. So if you're excused, you can go ahead and leave and go about your business. You don't need to go back to the jury assembly room or anything else like that. So I'm going to, you okay? It's just one of those days. It's all right. Sometimes it happens. It's okay. All right. We might be able to get you a new one. It's okay. It's a Tuesday. All right. So if I excuse you,
That is Aiden Fucci, Steve. That's what we were listening to.
oh, and everybody else needs to remain in their seats. So I'm excusing juror number 4 in the mask. In the front, juror number 12. Juror number 20 on the end. Juror 20 on the end. That would be you. You're excused. Yep. And I just remembered what I learned from yesterday, and that is to excuse the people in the back first. So I'm gonna change it up a little bit. I'm gonna excuse juror number 71 in the back. 73. The gentleman next to you. 73. Yes, sir. 74. 68. And 67. Wait a minute. Yep. 68 and 67. Oh, 68. 67 is already gone. 67 was the gentleman with the heart condition.
Yeah.
Okay, and so now we're up to speed here. 62 on the end, yes. 59. No, hold on. Don't, no, stop. Go back. You're right. Okay. Okay, so let's see, I had 60. 62. Thirty-five, 37, 39. I'll do the and Drew 30 and okay, so that worked a little bit better. Okay, now let's start the next part. Okay, so what we're going to do now is I'm going to have the staff hand out some witness lists for you. These are people that we anticipate will be witnesses in this case. The question that I'm going to have for you is take a look at it and let me know at the end if you know anybody that is on that witness list. Is counsel up to speed on who I excused, or do you need to see my sheet? Prosecution? Are you guys okay? Mr. Tellini, are you okay? Okay. There are a lot of witnesses, so if you want to write some names down or something like that, there are those notepads there on the bars in front of you and some pens if you need to do that, if you have a question about it. I'm sorry, I didn't realize Todd left. I should have helped you. I'm sorry. Okay. Ran a little short.
Thank you. Oh, sorry.
Kathy, can you get that door for me, please? Thank you. Got two more. All right, has everybody had, is there anyone who has not had a chance to look at the witness list yet? If so, please raise your hand. All right, it looks like everybody has. Prosecution, is there anyone else that the prosecution intends to call as a witness in this case that is not on that list?
No, Your Honor, thanks.
Defense?
Yes, Dr. Rhonda Niederhauser and Caitlin Craig.
All right. Do any of you think you know, does any juror think they know any of the potential witnesses in this case? Please raise your hand. Okay, it looks like we have a couple. Let me start in the far back. Juror number 66, who do you think you know? Who? Okay, and how do you know Detective Sapp? Okay, okay. And I don't know, this is a potential list of witnesses. I don't know whether these witnesses are going to actually be called, and some of them may be important, some of them may not. Some of them may have, 2 minutes worth of testimony, and some may have 2 hours. I don't know. The question that I have for you is, could you judge Detective Sapp's testimony just as you would judge anyone else's testimony? Okay. All right. No, that's fair. There was another hand, there it is. Let's see. Hold on a minute. Juror 45, who do you know? No, wait a minute. This woman here, you had your hand up? Yes, ma'am. And what? Right. What kind of job did that Josh Johnson have? Does that sound like the same person? Probably not the same person. Okay. All right. And was there another hand back here? Okay. In the back, and juror 61. Yes, sir. Brandon, last name? Bullard. Okay. Since the name sounds familiar and you're going from that, it sounds like not close friends. Okay. If you were, if this, suppose that this is the same Brandon Bullard that you knew. And I've had it happen where people don't realize they know somebody until they take the witness stand. And I remember one trial where I had where a juror gasped, and I'm going, how bad is this? She just said her name and she was just going, oh, I remember. So we had to have a conversation with the juror, and she said, oh, I remember from school years and years and years ago. So the question is not whether you know them. The question is, can you judge that person's testimony just as you would judge anybody else's testimony? So the mere fact that even if this is the same Brandon Bullard that you may have known from high school, okay, so even if it's the same person that you may have known from high school, you can just look at their testimony just as you would anybody else's. Yeah, okay. All right. Is there anyone else? Oh, over here. Let's see. 2, 3, 4. Juror 15.
The F&E nurse.
The who?
The F&E nurse at UCL.
Amanda Ben.
Amanda.
Okay. And how do you know her?
Co-workers. I used to manage the HIM department for UC Health centrally.
Okay.
And I've done medical records as well as the actual F&E medical records. I've looked through them. I've worked very closely with that department.
Okay. And again, I don't know how she fits in or what it is that she did. But would you be able to judge her testimony just as you would be able to judge anybody else's testimony?
I might give more credence based on the knowledge I have with medical records and stuff like that. So I might think that that would bear more validity.
Well, that's a little different question. Because what I'm asking here is not so much the records or the work that she did, but her as a person. So suppose she comes in and she testifies about something that has absolutely nothing to do with the records or anything like that. Would you be able to judge her testimony just as you would judge anyone else's testimony?
I'm not sure, to be honest.
Okay. So do I have it right that what you're really looking at is you have some experience with the type of work that she does, and because of your familiarity with that work and having done some of that work at that facility, if she were to testify about that, you would give it more credibility.
Probably.
Okay. So he's just gone. Don't worry about it. Okay. At this point in time, I'm going to have the attorneys give you a 2-minute mini opening statement. It's just an opportunity for them to tell you what they think the issues in the case are. It's not necessarily what you'll find them to be if you're selected to serve as jurors in this case, but it does give us a starting point for a conversation. With that, prosecution.
Morning. January 27th, 2020. Gannon Stauch, 11-year-old boy, was taken, brutally murdered. The evidence in this case will show that the person who murdered Gannon Stauch is the defendant seated over here to my right. And when you look at the evidence in this case, you have to evaluate it as to what's going through her mind at the time that she's killing Gannon. And the way you do that is look at her actions and what her actions were. What her actions were, stabbed him times. Gannon was fighting for his life. He had his arms up. He's got cuts on his hands, cuts on his arms. He's got 3 stab wounds to the chest. Got a stab wound to his head. Actions. He also took a blunt force object and crushed his skull. Fractured his skull. Actions. Then she took a gun. She had to get the gun. She fired that gun 3 times. One of them striking him in the chin, causing his death. But it's not only during the commission of the crime that the evidence is going to show that not only did she participate and do this crime, but she was legally sane at the time when she did it. Because she did actions afterwards. When she fired the gun, 3 shell casings come out. Those shell casings are never found because she took the time to pick them up. Not only did she take the time to pick up those shell casings, she took up the time to clean up the mess she made because he was killed in his own bedroom. And there was blood all over the wall. There was blood all over the mattress and blood on the floor. And she took the time and effort to clean that up so that she hopefully would not get caught.
Wrap up, please.
She also gave numerous versions of what happened to Gannon on January 27th, 2020. The first one was that he just went to a friend's house and ran away. She changed her story depending on what evidence was presented to her. At the conclusion of this case, you'll see that her actions led her to the charges, and we will be asking you to convict her of every charge that she's charged with, and we will be asking you to find her legally sane at the time that she killed Gannon Stauch. Thank you very much.
Thank you. Defense?
What? All the things Mr. Young just told you, we're going to hear. A horrific, violent event, a brutal homicide. We're going to hear that Ms. Stauch afterwards gave numerous versions, stories. Afterwards, each growing in, each becoming more irrational, as she told. You'll also hear that the evidence circumstantially will clearly indicate that after this 11-year-old boy was killed, that he was stuffed in a suitcase, transported to Florida, discarded there, and left for over a month until his body was found. You're going to hear and see photos from the autopsy of that boy who had been brutally murdered and that was in a state of decomposition. We'll also hear, though, from Dr. Dorothy Lewis. Examined Ms. Stauch for over the course of 3 days and 14 hours, who's from Yale, who's had a 4 years of experience dealing with this, that based upon her interviews and her review of the mental health history that Ms. Stauch has had, that she, among other things, suffered from dissociative identity disorder, formerly known as multiple personality disorder. That when this event took place, she was in a psychotic state and detached from reality, and in the opinion of Dr. Lewis, was insane. Thank you.
All right, thank you. You've heard the attorneys tell you a little bit about what they believe the facts in this case are and what the evidence will show. Please understand that nothing that the attorneys say at any point in time is evidence. What is evidence is when a witness comes in, raises their hand, swears to tell the truth, takes that seat and tells you what they have to say. And then there are rules of law and evidence that apply to their testimony as well. The attorneys never take that oath. They are paid advocates in hoping to convince the jury of a particular position. So nothing they say is evidence and is entitled to any evidentiary weight. In this case, you will be asked to render a decision based on the evidence presented in this courtroom and the instructions that I give you. Even if you have heard or read something in the media, the real question is whether you can put that aside and decide this case based on the evidence you hear in the courtroom. Is there anyone here who thinks that they may have heard something about this case, either I'll just say media in a wide variety to include Facebook, and I have no idea what's out there. But does anyone think that they've heard anything about this case in any form or fashion, from friends, from television, radio, print media, anything like that, and thinks they cannot set that aside and decide this case based only on the evidence presented in this courtroom? Please raise your hand. Okay. Again, we're going to start in sections. So juror number 1, yes, ma'am.
It would be very difficult for me to be impartial. I just my evaluation's the first one.
Okay. And there were other hands up here. Let me go in the back. That would be juror number 7.
I too have heard a lot on TV, seen a lot, and talked a lot about this, and I really don't think I can partial on this because I don't agree with the insanity. I really think it would be hard to change.
Okay. And you understand that, I mean, people are talking all kinds of what conclusions should be drawn from sanity evaluations, but there's not any evidence of that or why they concluded. You would actually hear the experts in this case make a determination regarding whether they, easy for me to say, why they did or didn't believe that she was sane at the time. Do you understand that? Okay. But you feel like your mind is made up pretty much? Okay. Front row, and let's see. 6. So juror 16.
I work at a grocery store and talk a lot with customers and other employees, and we've had quite a bit of conversation as everything's going on with that, and my mind is basically made up as well. And I have an 11-year-old son as well.
Juror 17.
Yeah, I'd like to believe that I could be impartial with an 11-year-old child. And from what I've heard, and I just accepting an insanity plea, it seems awful.
Okay. So for you, it's not the publicity issue, it's the 11-year-old issue.
It's that, and I mean, I remember reading about it. I didn't go into detail with it.
Right.
I remember having a very visceral, emotional reaction to the situation.
No, and I appreciate that response because we do a lot of different kinds of trials, and unfortunately, some of them involve young victims. We have this case does not involve it, but And that's kind of why I'm choosing the crime, even though it sounds, and it is terrible, a sex assault on a child. We deal with those oftentimes. And I often hear from jurors say that they would have difficulty dealing with that kind of crime because it involves a child. And the question is whether or not you think that you can put that aside and just decide the case based on the facts. Do you think that you can do that?
Don't know.
Okay. All right. And was there another? I'll get to you in a minute. Was there another hand in the front? No. And juror number 6. Yes, ma'am.
Hard time with the incentive. Talked with my family and friends about.
What is it about? You said that you have difficulty with the insanity plea. What is it about that you have difficulty with?
I just don't believe that she's a.
Okay. And it could be if you haven't heard any evidence about this case yet, right? Okay. So it sounds as though, I'm just trying to understand what that is based on if you don't have any evidence on it. Okay. And before I get too much further, I'm going to ask questions about insanity separately. What I'm trying to find out at this point in time is the issue with respect to publicity and whether or not there's anyone who believes that they would have difficulty setting aside publicity that they may have heard in this case and deciding the case based on the evidence. Is there anyone who feels that way? All right. Juror 8.
We were looking at house sessions in January of 2020, and we actually drove by, I think, where a lot of this was going on, and that, we were curious about what was happening, and we looked into it a little bit. And it's shocking here at that time, and as it's grown, we.
Okay. Would you be able to set aside the publicity aspect and decide this case based on the evidence?
I'm not sure.
Okay. And is there certain things that you remember from the publicity that are causing you an issue, or?
I feel relatively biased on what child deserves, what no one deserves.
Okay. And I'm fairly certain, and I've presided over a lot of trials. And I think Mr. Tellini has painted at least some of what I anticipate the defense will be. And I don't think you're going to hear anybody in this courtroom say that this was deserved. I don't think, frankly, you would hear anybody in any courtroom say that this was deserved. The real question here is whether or not it meets the standard set forth for conviction or has the prosecution proven beyond a reasonable doubt everything that they're required to prove beyond a reasonable doubt. So, and I'll get into that in just a minute. Again, at this point, I know it's hard for people who are not trained in the law, but at this point, I'm only asking a very specific, very discrete question. And that is, forget everything else, just with respect to publicity. Is there anything about the publicity that you think you could not set aside?
I'm not sure.
Okay. No, that's fair. Okay. All right. And back here, this section in the front row, any hands? No. Juror 55? Yes, sir.
My opinion on this is that I believe it's evading, talking about taking responsibility for it. Basically copying out and trying to shift the blame to something else other than the person.
Okay, let me stop you for just a moment, because those are all valid opinions and opinions that I need to know about. But my question is very narrow, very narrow. The only question that I'm asking at this time is whether or not there is any publicity that you have seen, heard, or experienced that you think you could not set aside. We're not talking about insanity. We're not talking about an 11-year-old. We're talking about just the publicity. I will get to those issues. I promise I will. But because of the way the law works, there are certain discrete ways that I have to go about doing it. So, by discrete, I mean I need to know specifically what the legal basis is for something. So I'm just trying to find out if there's publicity that you've been exposed to that you think you cannot set aside.
Point to another state with filed a pursuit case. That's
Okay. All right. On this side, in the front, Juror 31, you have the most, that would be you, the one with the unique purse.
Yeah, there has been lots of. I've been wild out in the area.
That's where you grew up? Okay.
Sister lived right around the corner from where this happened. I didn't participate in part of it, but all the publicity that has been going on, my mind is kind of been made up. And I'm positive I can't overcome.
Okay. Anyone else in this front row? Okay, second row, Juror 43, striped shirt. That's you. Yes. Okay. Juror 44. No, the girl in the gray sweatshirt. Did you? Oh, I thought you did. I'm sorry. Okay. Juror 45. No, that's all I need. Let's see. Oops. And let's see, that would be your, I think you're in the wrong place. Yes. Okay, because I have, yeah, that's what I have, but I have him as being excused.
no, I still have them.
Okay, all right, then I must have marked it off wrong. Okay. Juror 47, go ahead. Yes, sir.
I experienced emotionally.
Okay. That's what I was confused a little bit when you said the construction site, not on this house, but there was construction out in the area. And so you drove by in that area every day. Okay, I got it. That's what I was a little confused there for a minute. Okay. Okay, next row back. You're 57? Yes, ma'am.
I don't think that I can change the case. I was foster children. I adopted the last 3. Don't, and I can be truly give what she may need. Wrong of me to do that. But my heart is already caring for this child. I had a cousin that was stabbed 27 times in Arizona. Then had her body part of my family. I just don't think that this is where I would.
Okay. All right. Anyone else in that row? Row behind. And last row, juror number 70.
So, social media aspect, I'm on all time. I'm on all. And from day one, I
Okay. Anyone else in that background? All right. All right. Now I want to talk a little bit about the process and the law that applies to this case before I move into a different area. Every person charged with a crime is presumed innocent. This presumption of innocence remains with the defendant throughout the trial and should be given effect by you unless, after considering all the evidence, you are then convinced that the defendant is guilty beyond a reasonable doubt. The burden of proof is upon the prosecution to prove to the satisfaction of the jury beyond a reasonable doubt the existence of all of the elements necessary to constitute the crime charged. Reasonable doubt means a doubt based upon reason and common sense, which arises from a fair and rational consideration of all of the evidence or lack of evidence in the case. It is a doubt which is not a vague, speculative, or imaginary doubt, but such a doubt as would cause reasonable people to hesitate to act in matters of importance to themselves. If you find from the evidence that each and every element has been proven beyond a reasonable doubt, you will find the defendant guilty. If you find from the evidence that the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, you will find the defendant not guilty. You may have to decide what testimony to believe. You should carefully consider all the testimony given and the circumstances under which each witness has testified. Consider each witness's knowledge, motive, state of mind, demeanor, and manner while testifying on the witness stand. And, depending on how you view the testimony, you may believe all of the testimony of a witness or part of it or none of it. A few minutes ago, you heard me tell you that the defendant was presumed to be innocent. This means that if I were to give you a verdict form right now and ask you to fill it out, the law would require that you find the defendant not guilty. That's because you've not heard any evidence in this case and the defendant is presumed innocent. That won't change or hasn't changed simply because the attorneys have told you what they believe the evidence in the case will show. Now, someone may ask you whether or not you think the defendant has done something wrong or else you wouldn't be here. However, that's an improper question. We don't just randomly select people from the street to suddenly appear in a courtroom as a defendant in a case. Obviously, there is a process in place which resulted in the filing of charges against the defendant. However, the charges against the defendant are not evidence either. The charges against the defendant are just accusations. The fact that the defendant has been accused is not evidence that the defendant committed any crime. As such, the defendant is presumed to be innocent, and until the district attorney presents sufficient evidence to overcome that presumption beyond a reasonable doubt, you must continue to presume the defendant is innocent. Stated differently, unless and until the prosecution presents sufficient evidence to overcome the presumption of innocence beyond a reasonable doubt, Ms. Stauch's guilt has not been proven. That's what the presumption of innocence means. You may find it helpful to think of the charges in this case as similar to a recipe from a cookbook. When we get to the end, there'll be charges, and each one of those charges has certain elements. And the prosecution must prove each one of those elements beyond a reasonable doubt. Now, for instance, suppose for a moment that you wanted to have a Denver omelet, and you took some eggs and you scrambled them up. You added some ham, you added some mushrooms, you added some cheese. In that event, you might have a really nice ham and cheese omelet, but you wouldn't have a Denver omelet. If the prosecution charges the defendant with a Denver omelet, the prosecution has to prove a Denver omelet. No substitutions on the menu are allowed. Proving ham and cheese omelet isn't enough. They have to prove beyond a reasonable doubt what they have charged and not something else. I also want to talk about the defendant's right to remain silent for a moment. Someone may ask you whether or not you think you would need to hear from both sides in order to be fair. Everyone wants to be fair, right? And you can only do that if you hear both sides, right? But that's an improper question, because that's not the process that we follow in a court of law. This isn't the Maury Povich or Jerry Springer show. The government brought these charges against an individual. Because of that, the government has the burden of proving the charges beyond a reasonable doubt. The defendant has no obligation to disprove the government's case. The defendant does not have to present any evidence or any testimony. In addition, every defendant has a constitutional right not to testify. The decision not to testify cannot be used as an inference of guilt and cannot prejudice the defendant. That's because it isn't evidence. It does not prove anything and must not be considered for any purpose. Sometimes you will hear attorneys ask jurors questions that are intended to elicit a response from you, such as, well, I know if I were accused of something, I would make sure that I took the stand and told my side of the story. That's probably a pretty natural response from everybody. I get that a lot from jurors. But as I indicated earlier, that's kind of a trick question, because that's not the process we follow in a court proceeding. In any event, does anyone know what the number one psychological fear in the population is? It's higher than a fear of dying, and most people find it even scarier than meeting up with a rattlesnake. Yep, public speaking. So, of course, what we do is we bring you all down here and have you speak in front of everybody else, and sometimes get asked about some very private matters in your life in front of a bunch of complete strangers. All of you have been subjected to questioning by myself. Soon you'll be subjected to questioning by the attorneys, and I want you to think on that experience. Were you nervous? Were you uncomfortable? If you had a choice, would you choose not to be questioned? The bottom line is that it is possible that the defendant won't testify, and it's possible that the defendant will testify. But regardless of who testifies and who doesn't, the question is always the same. And that is, based on the evidence that has been presented, whatever that evidence is, has the prosecution proven beyond a reasonable doubt that the defendant is guilty of the crime charged? Is there anyone who thinks that they would have to hear from the defendant before deciding the issues in this case? Please raise your hand. No response. Is there anyone who thinks that they cannot give the defendant the presumption of innocence to which she is entitled in this case? Please raise your hand. Okay. I'm sorry, juror number 5. Tell me about that.
I think all murders should be death penalty cases. I think the insanity defense should not exist.
Okay.
I could go on.
No, I understand your feeling. And I mean, do you need some water back there? Are you doing okay? Okay. All right. If there's anything that we can do, throat lozenges, anything like that? No, it's okay. I just want to see if there's anything that we can do to help you. Okay. All right. No, I understand that. And I understand your feelings. And juror number 6, you had your hand raised. Tell me about that.
I just made up my mind.
Okay. Anyone else in the back row? Juror number 7.
Made up my mind too, and I just don't think I'll be able to change it.
Okay. Juror number 8.
I feel like I made my mind. Believe in insanity.
Okay. Juror, I'm glad you did that because I almost missed it. Juror number 10. Okay. And in the front row? Oh, no, I already got that. Actually, juror number 1. Okay. Missed. Tell me about that. Juror number 1. Okay. In the front row, juror number 13.
I don't know how I got lucky enough to be 13, but my problem is, I mean, if you kill somebody, you kill somebody. Whether you're insane while you do it, you still killed them. The insanity thing is.
Okay. Let me see if this helps. Okay. Because it's a really complex area of the law. And somebody else had mentioned the death penalty, and Colorado does not have the death penalty anymore. It did for a while, and I actually presided over a death penalty case. And even when the law recognized the death penalty, you could have a first-degree murder, but constitutionally, not every first-degree murder was eligible for the death penalty. At the time that Colorado had a death penalty, there were 17 aggravators that could be considered to determine whether or not the death penalty should be imposed. One of which was killing a number of people in a number of different episodes. Another one was doing it in a reckless fashion. So that's why it was applied in the Aurora theater shooting. So because you had a number of murders there, you also had it done in a reckless manner. It wasn't targeted in any specific person. So that's what that was about. One of the issues about murder and sanity, if you are selected to serve as a juror, you will receive an instruction that is worded by lawyers. I just don't know how else to say it. And it says every physical act must be accompanied by a culpable mental state. And that's actually the language that it uses. And the reason for that is people can do things and certain actions happen, but you're not always held responsible for that unless some other mental state was going on. Oftentimes, the easiest thing to deal with are tickets because that just requires a certain act. You're going 65 in a 50. We don't care whether you meant to do it. We don't care whether you knew you were doing it. Those sorts of things. The sheer act of doing 65 in a 50 is enough. In other cases, criminal law is designed to modify behavior. And if you don't know that you're doing something, or you have a condition that is occurring such that you don't understand exactly what's going on. And I've had cases where insanity was pled before as well. I had one where a person beat their mother to death with a guitar. And I won't go into the long facts of that, but ultimately the law takes the position that it is not proper to hold somebody responsible for an act that maybe they didn't know that they were doing, or that they didn't intend to do under the circumstances. Does that sort of make sense?
I guess yes, but
Okay. And then I'll get to the insanity part, which is a little bit different, because the insanity part is that there was, and I have the instructions, and if you're selected to serve as a juror, you'll get those. But the insanity part is intended to have the jury closely examine the mental state of the person at the time the crime was committed, because each act has to be accompanied by a culpable mental state. And the prosecution has the burden of proving both of those beyond a reasonable doubt. Does that make sense so far? Okay. So in an insanity plea, what the jury focuses on is the culpable mental state issue, and whether or not there was that mental state that is associated with that crime. It could be, in Colorado, there's a number of different ones. There's intentional, there's knowingly, there's reckless, and that's pretty much it. So, but all of those have different, very specific definitions. And so the question is, was something going on such that they couldn't form a particular mental state? Does that make sense?
it does. The problem I have with it is at the time of the crime, this was this mental state. They're being evaluated after the fact. How do we know what that mental state is at the time that somebody's getting killed?
It's, and that part I get, and that part is for the experts. And you would also get an instruction if you're selected to serve as a juror, you'll get an instruction about what an expert is and those sorts of things. But ultimately, the last sentence of that instruction reads, you may believe all, part, or none of the testimony of an expert. So you can listen to what they have to say. You can say, this makes sense. In the Aurora theater shooting, it did. In other cases, in the case that I had where the young man killed his mother, it did. And I actually was the one that made the decision in that case. That case was tried to me. So whether you believe something or not is an entirely different question. And I'm not asking that. And there's nobody that's going to ask you that, because that's improper. That's invading the juror's province. What you choose to believe is up to you. The question is whether or not, simply because it's an insanity defense, you're going to say, just not going to happen. Don't care what the law is. Not going to follow it. I just don't believe in it. And that's my question for you. Do you, or could you look at this and say, well, I don't know what the evidence is going to show. It might not. I don't know. Where are you on that scale?
I don't know.
Okay.
I mean, you don't know what you don't know, right? I haven't been
Right.
presented with evidence and.
No, and that's fair. And that's all I'm asking for is an honest answer. And sometimes the honest answer is, I don't know. And it sounds like maybe you have to wait until you get there. It sounds like, but at this point, you don't know. That's fair. All right. Anyone else in this? Okay. Juror 15?
Yeah, to be honest with you, I'm not really sure on if I'd be able to actually do that, and it's coming from a personal place. and having had some experiences as a child as well and culturally, I think it would be really difficult for me to be unbiased
Okay.
in my responses and how I would internalize that mentally.
You said something there, and I'm not trying to be insensitive, and I certainly don't want it to come across that way. But you said culturally, and I didn't, give me some context.
I was raised in the West Indies on one of the islands, and what happens is, and I can speak because I was raised there, and most of my family's from there. I do see that a lot of child abuse does happen, and it's natural. It's like normalized. Okay, so
Okay.
I mean,
Right, widely accepted.
yeah, it's
Okay.
generally accepted.
Okay.
To put you in your place, and that's the
Got it. Okay. All right.
right? So like personally, I've been hit with pots in my head. I've been beat with brooms. I mean, I've been hit with hangers, and this is normal. Okay, so I would really have a difficult time processing that and really coming to a place where I would be unbiased. And that's just the honest truth.
Okay. No, yeah, thanks for giving me some context. I understand it a little bit better. Juror 16, did you have your hand up? Yes, sir.
Being a father of an 11-year-old boy, I don't think I can be unbiased in this situation.
Jurors, did you have, juror 17? Yes.
I have a question.
Yes.
You talked to us about presuming innocence, right? But when I hear, if by reason of insanity, what I hear is really she's guilty. We have to decide whether or not her mental state excuses that.
You know, you have probably saved a lot of people 3 years of law school. Because to an extent that kind of is accurate. It is, go ahead, come on. You sort of hit on an issue with respect to sanity, which is the mens rea. Here's what you need to keep in mind. The prosecution always has to prove everything under reasonable doubt. Okay. So in this case, the instruction, it always starts out with, in the state of Colorado, on or about the date and place, and it actually has that kind of numbered out. And then it will say with intent, and then it will have some other descriptors. And they have to prove every single one of those things. And then at the very bottom, I think it's paragraph 6, or the very last paragraph will be, the prosecution also will have to prove essentially that she was sane at the time. They have to prove that she was sane. So with every case, the prosecution has to prove everything. There's no assumption necessarily that she did anything. As I said, if I give you a verdict form right now, you would have to find her not guilty because there's been no evidence that's been presented.
Well, I understand that in theory, but I can't accept that logically. That's what I'm struggling with.
What, help me understand the logic
But I
issue.
understand that, we haven't had any evidence presented to us. That two lawyers speak to us. They both agreed on the circumstances. Nobody said, no, she didn't do it. Just said that she was in a particular mental state.
Ah, okay.
So that's kind of what I'm struggling with, because
Okay.
I don't know that it would matter what mental state she's in. I still think there's a punishment due.
Okay.
That's what I'm struggling with. I don't know that excuses anything.
Okay. Let me deal with both of those issues. Because they are separate. The defense, I'm sorry, let me back up. The prosecution will always have to prove everything. So they're going to have to prove that this crime occurred. They're going to have to prove that it occurred in a specific way. They'll have to show a manner of death. They'll have to show all of those kinds of things. They will have to show that it was this defendant and not somebody else that did it, or somebody unknown that did it. So they'll have to tie it to this defendant. Then the issue about punishment that you brought up. In the law, the position that is taken in the law is that if you have this mental state, so you either knew what you were doing or you intended to do what you did, and that caused you to act in a certain way, which resulted in the commission of a crime, then you should be punished for that. That makes sense, right? On the other hand, if you committed some acts, but you didn't intend for that to occur as defined by the law, or you didn't know that that was going to occur as defined by the law, and there's definitions of what intentional means and knowing means, so you'd have to figure out whether that applies or not, then the law takes the position that you shouldn't be punished for that because you didn't have control over the physical action that took place. As a result, you shouldn't be punished to the same extent as somebody who intended for that to occur and really set about a plan for that to occur. Does that sort of make sense?
It makes sense.
Okay.
I just don't know that I can put away
Okay.
I don't know that I can put aside how I feel right now, regardless of that. That's what I'm struggling.
No, and let me get to this very last part. That's where the insanity comes in, because if the jury were to determine that the defendant first of all committed this crime, and the defendant was insane at the time that the crime was committed, there would actually be a verdict finding to that that says that. Then what happens is the defendant is committed to, it's actually the custody of the Department of Public Health and Safety, and is committed to their custody and placed in a facility, a mental health facility, until such time as sanity can be restored. The idea being, under the law, that we do impose punishment on people who should and ought to be responsible for their actions. If somebody is determined not to be responsible for their actions because of a mental defect or mental health issue or something of that nature, then the idea is to get them the treatment or the help that they need so that they can be restored to a better mental functioning.
So what happens if she's deemed to be sane 10 years?
I don't have the answer to that. What I can tell you is that there are hearings that go through if a person is found to be insane, they go through hearings, because I've had those. Understand it. May not change your mind, but it helps you understand a little bit more.
Yep.
Is that fair? Good. Okay. All right. Anyone else in the first row? First row over here. Juror 20. 23, yes, sir.
Exactly the same. thing for 17.
Okay.
Struggle to put any kind of belief in a
Because who you choose to believe and what evidence you choose to believe, if you're selected to serve as a juror, that's your call. I'll just stand up, it'll be easier. That's your call. And
I understand that.
okay, so the issue, it sounds as though the issue is you're not sure that you would believe a psychologist or psychiatrist. Is that fair?
That's correct.
Okay, all right. Anyone else in that front row? Yeah, you're on deck. 41. Yes, sir. Yes, ma'am.
So I think similar to the gentleman in the dark jacket, I feel similarly. It seems awful convenient, that this person is being that they're, well, after this event occurred. To kind of topple on top of that, I don't have to be unbiased. My father just retired after 27 years in law enforcement. He's a police officer, a sergeant, a commander. And so growing up, when you have someone like that in your life, you can believe a lot of the things that they talk about and they believe. So kind of coupling all of this together from what other people have said as well, my mind's already made up. I have an opinion already, and I think going into this, it would be extremely hard, if not impossible, to sway what I've already kind of believed in my head.
Okay. All right. Juror 55, now we can talk about the issues that you had about the sanity and those sorts of issues. Did you have anything else that you wanted to tell me?
Oh, Your Honor, I go, let's say once again, I just think it's trying to take responsibility.
Okay.
Access. Kind of a cop out.
Okay. All right. Thank you. Anyone else in that row? No. All right. Over here, first row. Juror 31.
I want to go back to this juror hit on a good point. Should you keep innocent until proven guilty? It sounds like from everybody's openings, guilty until proven innocent. Because nobody did, she didn't do this. Everybody seems to agree she did do this. What her state of mind was. And then I'm gonna go back here where he just said cop out with a word in my head. Cop out is me coming, I have a mental health background. I've worked in mental health before. And I was just a mental health tech for I worked in mental health. And working with patients. I've had one patient tell me literally, like I could kill you up in here. He was like, I'd like to, I wouldn't do it. But I'm a mental health patient. What's gonna happen? And so yeah, I'm just not, I'm really out of it.
Anyone else in this front row? Next row, and juror 44. Yes, ma'am.
I work in childcare and I also have a background. I feel like
Juror 45. Okay. Okay. All right. Okay. Okay. I I think I understand from everything that you've said. Okay. All right. Anyone else in that row? No. And the row behind, that would be juror 57.
I still go back to the thing of, I cannot change how I feel and what I think about this case.
Okay.
A child that somebody who is supposed to be taking care of them and stand from that. I have it very hard. I could not give her what she needs. My mind has been made up. I hate to say that, but I cannot change something.
Okay. Row behind. Juror 65.
I'll just say I appreciate the way your family explained, you know, the more you explain it to me, the firm of where I'm at. God's law. God's law has already been stated, basically. Colorado is giving her a way out of penalty. I do not think Colorado law supersedes God's law. That's at the root of an awful lot of discussion here. The question was, can I give her the presumption of innocence? And we're not, you haven't asked to get found people. But the question is so intertwined that I can't allow a presumption of innocence.
Right.
I'll keep it that, but I can go further, but I appreciate that.
I appreciate your honesty. Thank you, sir. Anyone else in that same row? One in the back, aside from number 70. No, great. I'm going to ask the jurors to look around the courtroom. The question that I have for the jurors is, do any of the potential jurors know each other? No? Okay. Council, approach for a minute, please. All right, so ladies and gentlemen, what we're going to do is take about a 10-minute recess. So if I can have everyone back, and before we go this time, we do honor the third grade seating chart. So remember where you are, and remember to take that seat when you come back. But if I can have everyone back in the courtroom at, say, 11:45, and here's what you can expect. You already saw me excuse a number of people this morning already. My plan is to excuse some more before lunch. That's why we're taking the break now, so that I don't have you have to wait around and come back at 1 o'clock or 1:30 or something like that. I need everybody to go out in the hallway. And then we will have you come back in at 11:45. All rise for the jury, please.
Quick update in the Trezell Jacqueline West case, guys. This is the one with
Going through the numbers.
the
just
sweet
for a
little
second.
boy.
Perfect.
Wait, that now may not be the time to do this. Let me see if they're going to end up discussing stuff on the break.
It's, well, it's a lot easier. Got big numbers. Are you doing okay? Is there anything that we can help you with?
No, it's just allergies.
No, I get that.
Sniff dust and yeah.
Okay.
Okay, let's see if I can read this without being interrupted. Okay, so over in that Bakersfield, California case with the two boys.
Thank you. You may all be seated. Record should reflect the jury has left the courtroom.
Oh, never
Give me
mind.
a couple of minutes to work through some things here to make sure that gotten everybody.
Okay. They've got a couple of groups. The first contained 70 potential jurors, and the second had 62. Filled out a hardship questionnaire. They're asking if they've heard media coverage of the case against them. What else? First 36 group had heard about the case, as had 38 in the second group. They ordered more than 40 potential jurors back for Thursday for more questioning. Interesting.
Mr. Allen, I don't mean this to be insensitive, but I thought that I had seen this as a piece of evidence somewhere in the case. Was Gannon autistic?
No.
There were only early concerns that he had something like that, but he was ADHD.
Okay,
Yeah,
that's
not autistic.
That's what I wanted to know. Thank you.
Don't get Letecia started. She'll tell the judge all kinds of stuff. So anyway, that's kind of where they are. It sounds like they're not coming back until Thursday. And then they're not going
I
to.
don't know if you want to be muted or not, but I just got a text that you're okay.
Yeah, no, it's still open and it should be. The jury's out, but we should still be broadcasting because it's still open. If somebody wanted to be in the back, that would be okay.
Additionally,
So
more
let's
jury
see.
panels will be called on Tuesday of next week.
Oh, but that does raise the question: are we
about
doing
this
okay
week?
otherwise?
Haven't picked up anything today.
So your microphones then they cannot hear you
That's my
over
understanding.
WebEx. Okay.
I can
That's-
check over lunch though.
Yeah, please do. That's good to know. Because that means I can control it from up here and that's a good issue. So let's see.
Teresa, the West case is the one with the little boys that were unalived. This is them right there. I'm sure that you'll remember their pictures. They were originally reported missing in December. Was it 2021 or 2020? Oh, it's been 3 years, I think. And law enforcement alleges that they were actually unalived well before that time, about 3 months prior to when they were reported missing. And they do blame the foster parents for it. Does this the picture of the foster parents help? Remember when they got up and they gave those speeches that everybody in the media was going crazy over? Amanda, I swear I need to have you as a co-panel. You're so good at saying it just the way properly. What, Amanda, what were the children's names? Sincere? What were their given names? Classic. Okay, Classic and Sincere. That was their birth given names. When the Wests adopted them, they changed their names to Oren and Orson.
Okay. So as the jurors are not present in the courtroom,
All right.
these are the additional strikes that I would make at this point in time. You guys ready? Juror 1, 5, 6, 7, 8, 10, 15, 16, 17, 23, 41. And I'm sorry, this is where my numbering gets a little bit off. I jump around a little bit more. 55, 31, 44, 45, 57, 65, 70, 47. So,
Is that last one 47?
pardon? 47 was the last one, yeah. And yes, and actually, I was going to say, I'll go through the list and tell you who I still have left. Okay. I have jurors 2, 3, 9, 11, 13, 14. Let's see, what would that be? Yeah, that's right. They're down in the hole. 18, 19, 22, 24, 25, 26, 27, 28, 29, 32, 33, 42, 46, 48, 50, 51, 52, 56, 60, 61, 63, 64, 66, 69, 72, and 75.
The only one that I think you didn't include was 43. I don't think any of us at this table have marked off 43.
43 should be marked off.
Should be.
Should be, yes. If I missed that, I'm sorry. She should be marked off. That is the woman with the striped shirt. It was in the second row back there. Mr. Young?
Yeah, if I may, I'd just like to supplement the record.
Go ahead.
When I was at the bench, I requested that you read the full definition of insanity for the jury. The people are concerned, and I understand where the court was going with that because you were focusing on the culpable mental state aspect of the insanity, but we're concerned that the way the record reads, an appellate court may look at that and say you didn't give the entire instruction. And so we would request that you do that after the break, and I could provide you at least a copy of the instruction that we have.
I have them.
If you have them, that'd be great. I don't know what the defense's position is on that.
I'll ask that in a minute, but I do have the instructions if necessary. But anything else, Mr. Young?
No, just that.
Okay.
Thanks.
Defense, what's your position? Yeah, I'm not inclined to do it at this point in time, largely because what I was trying to do was, I hope I did a okay job, decent job, in trying to explain that what we try to do in the criminal law is modify behavior for someone who does have the ability to control their actions and chooses not to, as opposed to somebody who acts but doesn't have the ability to control those acts. And I don't, insanity is a complicated area of the law. It has specific instructions for it. And I know that we would be talking about mental disease or defect and moral obliquity and mental depravity and those sorts of things. And I think at this point in time, we would end up instructing people who aren't jurors. So I'm not inclined to do that. I may revisit that depending on how far it goes and where it goes. I understand the jury is struggling with what we understand an insanity defense to be, which is, it actually is legal avoidance. I mean, that's what it is. It is, and I don't mean that in a disparaging way. I just mean that in a definitional way. It is typically insanity is, there is an agreement that certain, or an admission that certain acts occurred, but that the law provides an excuse, which is how it's defined. That's legally how it's defined, as an excuse, which excuses the behavior. In this case, that's all I was trying to convey, was that that's what it's for. The defense in this case, I recognize, has the right in every case to require the prosecution to prove every element of the charge that has been brought against the defendant. And at this point, it sounds like it's a tactical decision, and that's okay. There's nothing wrong with that. I'm not faulting the defense for that. It does, however, leave the jurors who are not legally trained in a position of trying to understand and unravel a complex legal issue. So that's it. Mr. Tolini, did you have any other record?
I did, Your Honor.
Go ahead.
I understand that the statute has been previously challenged and been found constitutional, that had the unity as opposed to the bifurcated sanity versus guilt phase. I think we have some pretty clear evidence that this jury, or the jurors that we uphold, have a difficulty time with that, and specifically difficulty with the presumption of innocence as it goes to the fact phase of the first degree murder. And again, I understand that, but I'm just making the record. It's my opinion that we have evidence that it is impacting the presumption of innocence. And at this point in time, I would be moving to bifurcate the fact element of the trial versus the sanity element.
Right. Prosecution?
And we would object that that'd be a violation of the law, and obviously it'd be certainly overturned if there were a conviction in this.
Well, I agree it would be in violation of the statute. I don't know that it would be overturned. It would all depend on whether or not they agree that the statute should be overturned. But the way that the law currently is in the state of Colorado is, and it has been found to be constitutional, is that they are both tried at the same time. I unfortunately have been practicing long enough to recall a time when they were not. So I understand where the argument comes from. But the statute now is that they are tried at the same time and determined by the same jury based on the same evidence. So the motion is denied. You'll have that for purposes of appeal if you choose to pursue that.
And then the only other thing would be my request, Your Honor. I think that the law is clear that the jurors can be informed that they find Ms. Stauch not guilty by reason of insanity, that she would be put in the custody of the department, CMHIP, more or less. I would object, though, to any explanation from the quote, any further explanation about what the process would be after that as far as her release or so forth. I think that kind of is getting towards punishment, and I understand the juror was asking the questions, but I would be
I was
objecting
thrown.
that in future.
I was thrown by it myself. So in the future, I will just explain that there is a statutory process to resolve that, and leave it at that. Okay, so I just want to make sure we're all on the same page. These are the jurors that will be excused, and we will have those other jurors that will be coming back this afternoon. Prosecution, do you agree with the jurors that I read?
Yes.
Defense, do you agree with the jurors I read? Okay. All right, so let's go ahead and bring them all in that we have left or that are gone. Oh, that are gone. Okay. Still working out okay. Okay. We got everybody? All right. Record should reflect that the jury has returned to the courtroom. Ladies and gentlemen, what I'm going to do is read off the names, or I'm sorry, the numbers of the jurors that will be excused. So at this point, and I don't want you to leave until I tell you to leave, and the reason for that is I want to make sure that I have the right groups. So it would be juror number 1, juror number 5, 6, 7, 8, 10, 15, 16, 17, and forgive me, this is where I start to jump around a little bit. 23, 41, which would be there on the end. 55, which is also on the end. 31. So you, ma'am? Yep. That's a great purse. That is just, I saw that when that was up earlier and I was just looking at it and I was going, what would be even better is if it actually worked. Does it really? No. That's amazing. Okay. I won't have you demonstrate. 31, 44, 45, 43, 57, 65. You know what? It's going to be easier for you guys if I come back there, isn't it? Well, let's do this again. So it would be 5, 7, 7.
Okay, he's just going to dismiss some people, and then I think they're going to call lunch. Do you guys want to go ahead and flip over to the Aiden Fucci trial?
From either council, anybody that you think that I have missed. For those people that I named or that I gave you the numbers for, you can go ahead and leave now. Wait, before you all get out the back door, is that somebody's backpack? That Joy, okay, no, it's good. I just wanted to make sure that somebody hadn't left. Okay. Nope, you're still here. You are juror 27. You're still here.
Okay, I'm gonna switch over real quick because I don't think we're gonna get anything good right now.
So here's what we're gonna do. I'll give you a little bit of a plan going forward so that you can see where we're going and what's happening.
Hang on.
When we're gonna take a break until about 1:15. And then so if I can have all of you back in the hallway at 1:15 to come back into the courtroom. What will happen at that point in time is that the attorneys will have an opportunity to ask questions themselves. I've been asking all the questions so far. They'll have an opportunity to ask you some questions about some issues that they have in the case. They are limited in time. If they appear to be rushing through something, hold that again.
Okay, so we'll flip over to Fucci.
Of a hand by stab wound.
So you indicate in any way that the hand was against some type of hard or solid object?
Certainly could be. Normally, we see these, the decedent will place the hand between the assailant and their body. So the directionality here is from the back of the hand to the front. Presumably, the hand is between the central core of the body, which humans reflexively protect. And that's why we have the stab wound going that direction.
States 9 double T. This is the right arm, that's right.
Yes, right wrist and forearm, 12 wounds, numbers 55 to 61. We're looking at the palmar surface with multiple stabs in the palm, and then all sharp force injuries, mostly stab wounds on the right wrist and forearm.
And in this particular photograph, you can actually see the other side of those injuries that went all the way.
Yep,
Is that right?
that's correct.
Q.
9QQ, we have additional injuries. We've seen photographs of many of these, but we have 62 and 64, which are on the right arm.
9R. More on the same arm.
Yes, because the wounds basically go from the palm, well, the back of the hand, all the way down to the elbow. And there's a large number of them on multiple surfaces. Multiple photographs must be taken to capture them all.
Same for 9SS.
Yes, here we're seeing wounds 69 to 71. 70 and 71 are superficial incised wounds, where the others are stab wounds, much like we've seen before. Soft tissue wounding.
And then there were also sharp force injuries to the left arm.
Correct. Here we have illustrated on the upper left arm wounds 45 and 46.
State 9W.
These are the wounds to the left forearm, 8 wounds. The ones illustrated in this photo are 47, 48, 50, 52, and 54. One can see there are fewer stab wounds on the left arm than the right.
States 9BB.
This is 49, which is the only wound on this side of the arm. So it has a separate photo.
9WW.
WW shows a gaping incised wound of the lateral aspect of the arm on the ulnar surface, extending across the wrist on a horizontal plane. That's nearby the wound we previously described. That's wound 53. It's a stab wound, superficial wounding there.
Dr. Fulci indicated that the defensive injuries indicated that she was warding off these stabs. Would that be evidence that Tristan Bailey, would that be consistent with her conscious, aware of her attack and fighting for her life?
Yes.
Would these injuries have been painful?
Yes.
We have a moment, Your Honor.
No further questions.
Hello. Hello, ma'am.
I don't have a lot of questions for you today.
No problem.
In terms of, so you took over this case and you were not the original medical examiner.
That is correct. Yes, ma'am.
Dr. Bulick actually did the report.
Yes.
You reviewed the report and you reviewed the photos.
Yes, ma'am.
And you were not present on May 10th for the actual autopsy.
No, ma'am, I was not.
You did not go to the scene
No, ma'am.
and you weren't involved with the actual collection of, for example, any DNA or the fragment.
No, ma'am, I was not.
So in terms of the blood loss, is it fair to say that on view, we didn't look at all of the organs, but on view of the paleness of the kidneys, that there's a lot of blood loss?
Yes, and the lungs. We do have a picture of the lungs. They're quite pale.
And so same with the liver, same with the lungs, that there's a significant amount of blood loss.
Yes. Yes, definitely.
And I understand that you've indicated that the heart was still beating at the time of these injuries.
Yes, the hemorrhagic appearance of the stab wounds to the lungs certainly requires a heartbeat at the time. So yes, we would not have the hemorrhagic appearance of the stab wounds. These are antemortem injuries to the lungs.
And with that in mind then, because you're seeing significant blood loss, is it also fair to say with this large amount of blood loss that there's loss of consciousness?
There can be, but it would not be instant for sure.
Right. Versus, for example, the single gunshot wound to the head, there's certain gunshot wounds that are instant.
Of course, yes.
But
This
when
is
you're,
not.
right, but when you're seeing this much blood loss, it would lead to loss of consciousness also.
Yes, eventually, yes, ma'am.
Even though the heart's still beating.
Yes, you would lose consciousness most likely before cessation of heartbeat, yes.
And then in terms of the, I'm going to try this word, pneumothorax.
Pneumothorax.
Right, there were two of them.
Yes, both sides,
On both
right and
sides.
left.
Go ahead.
I was just going to say they would have collapsed the lungs.
And that would lead to loss of life.
Yes.
All right. And is it fair to say because you have both of these pneumothorax, meaning one on each lung, that this collection or even the cluster of injuries would promote the loss of life in a faster time space?
Faster, but certainly still not instantaneous.
Right. Again, the distinction being the gunshot wound to the head.
Right.
All right. So in this particular instance, then, is it fair to say that you didn't see any healing of any of these injuries?
Oh, no, none of these injuries would have been healing now.
Right. So this isn't a type of, this 114 didn't take a course of hours or days.
Oh, no, this all happens relatively quickly. Yes, ma'am. All wounds on the body show a appearance that is acute. There's no healing at any wound anywhere on the body.
No, Your Honor. Witness be excused.
Thank you very much, Doctor. You're free to go. You want to take a break now? For
Ah,
we'll just
shoot.
take 10-minute recess. I'll let you, if you can remove that TV as well.
Well, that sucks. They're going to go on break now. The cool thing about this not having a jury and it being in front of a judge is that it seems like it goes by a lot quicker. The judge knows what he can and cannot accept in considering the sentencing. And Steve says, yeah, they're trying to make him look as young as possible. I believe that. Yeah, maybe they told him, look, cut your hair this way, do this. I don't know. Very cocky. I'll tell you what, let's watch my video that I did yesterday that kind of gives us a summary of what happened. Yesterday, and that'll catch us up. And if you've already seen it, I apologize. I just think this is a good time to do this because oh shoot, hang on. It would help if I did a screen share. There we go. This is about 5 minutes long. Aiden Fucci, who has pleaded guilty to the unaliving of 13-year-old, at the time, 13-year-old Tristan Bailey in 2021, went back into court today for a hearing prior to his sentencing. This apparently is going to be a 3-day process, so we may not actually hear him being sentenced until Wednesday later in the day. Fucci came into court, looked like just like a feeble little thing. He's 16 now. He was 14 at the time of the unaliving. He had 0 people sitting behind him in the courtroom. No support whatsoever. Uh, the parents and the grandparents of Tristan Bailey were there, obviously, with some of Tristan's friends supporting them as well. And they just look so beaten down. I'm so glad they're not going to have to sit through a trial. I just can't imagine what they're going through. So, God bless them. You know, we'll be praying for them that after this they can have some type of resolution, some type of closure. Although I don't know if you ever get closure when your child is taken from you so brutally. So today they came in with I'm sorry, there was 3 motions, 2 of them were kind of linked together. One was discussing the pre and post conviction behavior of little Aiden. Apparently, he's been very disruptive in jail. He's been manipulative and physically, he's been getting into fights, and he's been manipulating other inmates in regards to taking their commissary. So apparently, he's just a little con man. Um, he's also been physically disruptive with the guards in the jail, and lots of threats of violence to others. The defense wants that taken out when the judge does his consideration of sentencing. They also want him to not consider the prior bad acts that little Aiden had while he was in school and for all the wrongdoing that he did in school, which was handled with school discipline. Apparently, there's been a lot. They've got teacher testimonies, things like that, that they're going to bring in for him to listen, for the judge to listen to before he makes his decision on sentencing. Judge came back and said nope to both of those. Let's hold off. You know, this isn't a jury trial. I'm a judge. I kind of know what to consider and what not to consider. So the judge said, let's hold off till sentencing. We might take some of these up tomorrow, but I'm going to consider all this and I'll get back to you how I'm going to move forward. So basically, he just wants to hear what it is and see if it's something that he should consider. Obviously, this little sociopath needs to be locked up because he's not even learning his lesson in jail, sitting in jail around the inmates. I guess that I'm gonna stop. Okay, I'll stop. I can't. Anyway, the third thing they wanted brought up, or the third motion they had, was that there was a Dr. Pritchard, who is a state expert psychologist. His evaluation of Aiden is based strictly upon court records, all discovery material, the autopsy, and so they wanted that brought out, or wanted that taken out of consideration, and the judge says no, he denied that. So here's what's going to happen. Tomorrow, the state's going to start calling some witnesses. They're going to have some victim impact statements. Wednesday, the defense is going to be bringing some stuff forward. And then I assume when they're done, we're going to hear the judge sentence. So what we're going to do, we're going to be live tomorrow on the Letecia Stauch case. and we're listening in on the jury selection on that because they won't allow cameras in the court. All we can get is audio. I really don't want to take away from that. So I think what we're going to do is tomorrow night, after I get off that live stream, I'm going to go in and try to piece some stuff together for you guys, do a real quick summary, put some stuff together so you can hear the base, like some key points of things that occur in the courtroom tomorrow in the Aiden Fucci trial. And then you can watch that tomorrow night. And I'll do the same on Wednesday as well. I just feel like I've committed to doing this stout jury selection, and I need to stick with that. And so, gosh, if I had 2 live streams, I would do the other, but I don't. So, with that being said, stay tuned, and I will see you guys at 9:30 a.m. tomorrow morning. All right, so that's it on that part. Barb, do you want to come up? Yeah, Barb and Crafts both are kind of listening in on the Fucci trial and making some notes for me. It's going to help me tonight, so I don't have to watch the whole thing. Okay, let me put the link up real quick. All right, Barb's going to come up and give us some updates on the Fucci case. I'll just drop the stream link for you. I guess I could take that banner down now since we're not listening to it anymore. You guys, I'm addicted to Blue Diamond Smokehouse almonds. Have y'all ever had those? It's what I've been sitting here snacking on while I'm watching this. I'm eating way too many of them. Oh, Amanda wants the West update. Okay, so let me tell you what this is basically. It says our first group of 36 had heard about the case and has 38 in the second group. Let's see if I've got any recent updates on the West case. Anything on Twitter? I don't think that. Nothing. Nothing new on Twitter. That is crazy. Oh, you like the wasabi barbecue ones? I haven't tried those. I don't see. There's no updates yet. Of course, they're like 3 hours behind me. So if it's 1 here, it's only 10 there. So maybe there hasn't been enough time for them to post any updates. I'll keep a lookout for that though. But it did say that I'll read this while we have quiet time. 2 panels of prospective jurors filled out questionnaires Monday ahead of the trial of a California city couple charged in the deaths of 2 of their adopted children. The first contained 70 potential jurors and the second had 62. They filled out a hardship questionnaire as well as a questionnaire asking if they've heard media coverage of the case against Trezell and Jacqueline. of the first group, 36 had heard about the case and 38 were in the second group had heard about the case. The judge ordered more than 40 potential jurors back for Thursday for questioning by attorneys. Okay. So then they're going to be calling some more again today. And then that's all we've got. Trial is expected to begin next week. I hear you, Barbara. I'm going to add you on. Okay. I have you on camera. Is that okay?
That's fine.
Okay. All right. What you got for us?
This guy is a sick person. When you stab somebody 115 times, and in discrete places, as the ME said, in at least one or two times that you can penetrate the skull.
Yeah.
That's some rage. They had so far 6 witnesses up there. And this defense guy, he cracked me up. He's like, well, detective, when you saw the body, were the hands still attached? And I'm like,
oh my
they never
gosh.
said the hands weren't attached. What the heck? Well, the body wasn't burned, was it? And they never said that either. I'm like, whoa, where did you pick that one up? You know, so he is just like,
oh, so here's all the things he didn't do. Is that what they're trying to say? Oh my goodness.
well, they're trying to really bring in this Dolphus Abshore, who was the last to see both Tristan and Aiden before they went for their walk. And for some reason, they're really trying hard to connect everything to him. But when Aiden tried to call him after they left, he'd already gone to bed. So he, and there's no video of him walking anywhere out of his house or meeting up with them, and a threesome walking down the street. So there's not much there, and the police have ruled him out as a suspect.
Okay. Good.
He Aiden Snapchatted from the back seat of the squad car.
Yep.
Oh, anybody seen Tristan out there lately?
Yeah.
And then they heard about it at the police station, and they're like, "Can you take his phone away?" And of course, he didn't have time to delete that. So that's part of the evidence, and some of it that the defense doesn't want to have shown.
Brought in. Yeah. And then they're going to, and then so who's gotten on the stand so far? They haven't brought up any of the teachers yet, have they? Because I think there's going to be some people from the school speaking as well.
Yeah, I think the defense is bringing them in. There's Detective Maloney. He's a retired sergeant from the New York Police Department, but he now works at that police station. And he's been on the police force for 20 plus years. So that was the first one. The second was Marilyn Butts. She's a CSI technician.
Yeah.
And she's the one that was there when they found the t-shirt and the jeans and the sneakers. In my mind, since the t-shirt wasn't wet, but the sneakers, and if you look at the tongue of the sneakers, you can see that instead of like a blood stain, the tongue is smeared, and it looks pink.
Ooh.
Yeah. And so those were wet and the jeans were wet, which tells me mom washed them.
Okay. So they got them after she washed them then.
Correct. So with the jeans, any blood stain, they couldn't get anything out of it because she had washed them. But for whatever reason, with the sneakers, she didn't see the blood spot above the upper shoelace,
Mm-hmm.
the hole. And so they were able to get DNA from that.
Oh, cool.
And it was Tristan's. So she must have tried to scrub that tongue of the sneaker. That's how it got all smeared and pink. But she didn't see that. It was a tiny little blood stain that she never caught on to. Where was that? I guess.
Oh, you know what, you guys, just really quickly, he's already pled guilty, so
Yeah.
they're not going to trial. This is just them trying to get everything in front of the judge so that he can do sentencing. Okay, go ahead, Barbara.
So the defense attorney was like, well, Trey wasn't forthright with you, was he? And they're like, we're not even considering Trey. We have everything, we need. And he's like, well, he says, well, was Aiden fidgety? Was he nervous? And of course, it's been a while. And
Yeah.
the detective said, well, no. So then he gets the deposition out. Well, let's go to page 8 and line 15. Let's review from 15 to 22. And what does that say? And so he was reading it, and it said nervous or fidgeting. The aha moment. I'm like, yeah, that's going to save his ass. That'll do it right there.
Yeah.
So they took a plethora of pictures at the scene and at the house. And
Fucci's back on.
Okay.
You want to just watch this and then we'll come back later?
Yeah.
Okay, I'm going to put it back on Fucci.
Help you God. Sir, will come up and have you stand.
This prosecutor's good, and the male is too.
Thank you. Good afternoon, doctor. If you would, introduce yourself to the court and let the court know how you're employed.
My name is Greg Pritchard. Last name is Prichard.
This is the one that
and
they
I'm a
didn't want
licensed
to bring
psychologist
in.
the state of Florida.
How long have you been a licensed psychologist in the state of Florida?
This is my 27th year.
And what is your educational background?
I graduated from the University of Florida in 1989 with a bachelor's degree in clinical psychology. I received my master's degree in clinical psychology from Forest Institute of Professional Psychology in 1992. I completed my academic work at Forest Institute for my doctorate degree, and part of getting your doctorate degree requires that you do an internship, which I did at Florida State Hospital in 1993, 1994. Upon completion of the internship, I graduated with my doctorate degree, magna cum laude, with a specialization in assessment and diagnostics in 1994, and subsequently licensed in the state of Florida in 1996.
And after your internship and you were licensed, just kind of walk through generally your areas of employment since that time.
After my internship that I completed in 1994, I was retained by the hospital, Florida State Hospital. I worked there for 7 years on several different units there. The first unit was a dual diagnosis unit. It was a unit for individuals who were intellectually disabled and mentally ill. I then worked at a civil admission unit where individuals are committed for long-term care to Florida State Hospital on the civil side. In other words, absence of any criminal allegations against them. And then I worked at a forensic admission unit at the hospital where the state's adults who have criminal charges and they're either incompetent to proceed or they're not guilty by reason of insanity and they require hospitalization. My duty was essentially to make an effort to rehabilitate them and return them to the community. And that was a 7-year span, 1994 to 2001. During that span, I had a 1 day a week private practice where I did forensic evaluations in the community. So competency assessments, sanity assessments, violence risk assessments, sexual predator evaluations under the state Sexual Predator Act. So all forensic related evaluations. And then in 2001, I resigned from the hospital and have been in full-time forensic private practice since then.
And you mentioned a number of evaluations that you conduct. When you do that, since you've been in private practice moving forward, are you often hired by both the state and defendants?
I am, yes.
And how have you done thousands of evaluations, Dr. Pritchard?
Thousands of evaluations, yes. I would say by this point, more than 10,000 forensic evaluations.
Okay. Do a number of your evaluations include criminal defendants charged with various amounts of violent crimes?
Yes, that is a very regular part of my practice.
And what about evaluating juveniles? Do you do that as well?
I've done that my entire career. In fact, before I got my doctorate degree, I worked on a juvenile psychiatric facility. That's where I started with juveniles. Since I've been licensed, I have had a contract with Apalachicola Forest Youth Camp, it's the state's facility where juveniles who are considered incompetent to proceed in the criminal realm, they are committed to Apalachicola Forest Youth Camp, 17 miles from my house. I've been contracted with them for about 15 years. I also regularly do juvenile competency evaluations, primarily in the Second Circuit, Leon County, and the First Circuit, Escambia County, Pensacola, those two circuits, but also others throughout the state. I also evaluate juveniles for sex offender recidivism risk. So sex offender juvenile evaluations. I also do evaluations of juvenile sentencing. So under the juvenile sentencing laws that came out between 2010, 2012, things that need to be attended to when sentencing juveniles. So I've done dozens of those under those juvenile sentencing laws.
And what you're referring to there is what's commonly known in our field as the Miller-Graham decisions, and then the rules essentially in Florida that came about in the statutes and all the factors that courts are to consider when sentencing juveniles. Is that what you're referring to?
Yes.
And you testified in Miller-Graham sentencings or resentencings of juveniles since those laws have changed?
Many, yes.
In reference to State of Florida versus Aiden Fucci, what were you asked to do in this case?
I was asked to do an evaluation of Mr. Fucci for sentencing purposes. So under the juvenile sentencing laws, there's one juvenile sentencing law, 921.1401 of Florida statutes, that specifically addresses things that should be considered when sentencing juvenile for capital murder cases. So I was asked to evaluate Mr. Fucci and compile a report based on the variables outlined in that statute.
Now, were you ultimately permitted to have a face-to-face evaluation with Mr. Fucci?
I was not permitted to see Mr. Fucci.
Okay. What categories of records, and we'll go through those, did you review in this case prior to forming your opinions?
Amber
I
Heard.
reviewed the St. Johns County Sheriff's Office investigative reports regarding the investigation into the disappearance and subsequent murder of Tristan Bailey. I reviewed the medical examiner's autopsy report as well as the autopsy photos. I reviewed transcripts from Mr. Fucci's girlfriend at the time, Zofie Bowman. There were 4 separate transcripts that I reviewed from her. I watched audio and video of 3 separate interviews of Mr. Fucci's best friend, Dolphus, Absher. He goes by Trey, so I'll refer to him as Trey if that's okay. I also reviewed a number of school records spanning Mr. Fucci's educational career. I reviewed pictures of the photos that were located in Mr. Fucci's room that have already been referenced. I reviewed a Snapchat folder that contained the Snapchat videos and texts that were sent by Mr. Fucci when he was in the back of the police car. I reviewed audio interviews of approximately 10 teachers that had familiarity with Mr. Fucci at Patriot Oaks Academy, where he was attending school as well as his previous school. I listened to audio of Tristan Bailey's parents, Forrest and Stacy Bailey, prior to Tristan Bailey being located. I reviewed an audio of a cousin. I have her initials here. It's, I believe, Hannah Cunningham, as well as a deposition of Hannah Cunningham. I had deposition transcripts of probation officer Dwayne Barton, who has had some association with Mr. Fucci at the Duval County Jail. Sergeant William Cox, who is from the Jacksonville Sheriff's Office, who works at the jail. Information, it was a deposition transcription from an ESE teacher that Mr. Fucci had, Alyssa Gates. I had deposition transcripts of brother Dylan Hicks. Not listed in my report, which I reviewed after I submitted my report, is a deposition transcript of brother Preston Fucci. Also a deposition transcript of friend Michaela Harris. I had a couple of Jacksonville Sheriff's Office incident reports that were written about Mr. Fucci since he's been at the Duval County Jail, one in January of 2022, one in October of 2022. I reviewed videos of Mr. Fucci in a court appearance, one on September 1st of 2021, one on September 8th of 2021. And then a letter and an audio interview of an adult inmate at the Duval County Jail with the initials AS.
Okay. Based on that volume of records you just outlined and everything that you reviewed in this case, photographs, was that information sufficient for you to form opinions in your area of clinical psychology as it relates to the factors that the court's to consider in this juvenile sentencing?
Yes, I believe so. There is a lot of records, and one central aspect of any forensic evaluation is the records that we have about the individual that we're evaluating. Now, there's a limitation. I'm obligated to express this. There's a limitation that I could not see Aiden Fucci. So that limits my evaluation process a bit. But because of the volume and density of the records I was able to review, a lot of teachers, family members, friends, I felt like I had sufficient information to draw a lot of conclusions.
Okay. And is this the only case you've ever been asked to assess on where a defendant, you haven't had that face-to-face, or a defendant didn't cooperate with you?
No, not at all. It's not uncommon for a individual in the criminal justice system to refuse an evaluation, to refuse to have face-to-face contact with a psychologist. So it happens pretty regularly.
Okay. And you're confident in this case that based on the records, they're sufficient for your opinions that you'll give here today?
Yes.
Okay. Now I want to move to the sentencing factors that the court is to consider. In your report, Dr. Pritchard,
Your Honor, at this time, defense renews the objection to the motion that was filed.
He already said no.
Right?
I don't think it was was it to my question or? I think I was about to move into opinions, so she's just making an objection.
All right, let me repeat what you were about to introduce.
I was about to begin asking him his opinions as relates to the factors we're here to discuss.
Based upon your prior arguments, you're renewing your objection.
Yes, sir.
And that objection is overruled. You may proceed.
Okay, thank you. Doctor, you did a thorough job, and you did address the nature and circumstances of the offense, which is factor A for the court. In your report, the court has heard a lot about that this morning already, as I believe you've been here as well through other witnesses. So I don't need you to recite those again, but just as they're relevant to the other factors,
Yes,
if you'll
ma'am.
just bring them up
Yes, ma'am.
as we walk through these. I kind of want to start with factor C in this case. That factor had you analyze and look at the defendant's age, maturity, intellectual capacity, general mental and emotional health at the time of the offense. And so I kind of want to talk, and that's a big section in your report, but I want to go through that and see what you were able to glean from the records of importance about Mr. Fucci in those areas at the time. And so we can start with teachers or however you want to start with that.
I think just if we will take each descriptor here individually, like age, for example.
Okay.
Factually, Mr. Fucci was 14 and a half years old when this incident occurred. The next descriptor under the C factor is maturity. And maturity is sometimes a difficult thing to assess. In many cases, you will have commentary in the records from, for example, teachers that describe the individual as mature or immature. So what I noted with regard to maturity for Aiden Fucci at the time was that there was, in all the records that I reviewed, there was no commentary that Mr. Fucci was immature. Okay, so I thought that was fairly remarkable that nobody's characterizing him as immature for his age. I did see two characterizations of Mr. Fucci being mature. So one of those characterizations came from his juvenile probation officer who has contact with him at the jail. Officer Barton described him as mature for his age. I also noted that his best friend Trey, when describing Aiden Fucci, described him as more mature than the peers, which is part of the reason that Trey described that he got along well with Mr. Fucci. So those were the only specific references to his maturity status from all of the records that I reviewed.
And similarly related to maturity, I think you have some comments noted about whether he was like a leader, characterized as a leader or a follower amongst his peers. What did you learn about that?
Sometimes you kind of glean a maturity level based on whether they're considered leaders in their classrooms or with their peers, or conversely followers. So obviously when somebody is described as a leader, they tend to be more mature than the peers that they're hanging around with, which is why they are characterized as leaders. So I saw two references, one from girlfriend Zoffie Bowman and one from friend Michaela Harris, that they believed and they perceived that Mr. Fucci was the leader when it came to him and his best friend, Trey Absher.
The next sort of descriptor in that factor is intellectual capacity or intelligence. What were you able to determine about Mr. Fucci's intelligence based on the records you had?
So I think the best place to start in terms of intelligence is this. His intelligence was never formally tested. So there's no school records that indicate he was given a formal Wechsler intelligence scale for children would be the standard one. So there's no indication that he was given one of those in the school environment. But again, though, I didn't see characterizations of Mr. Fucci being unintelligent or having cognitive problems. Okay, when we say cognitive problems, it's synonymous with intellectual problems, being not very smart or having cognitive processing or comprehension problems. There was no characterizations of that. The only specific reference I saw to Mr. Fucci's intelligence came from Sergeant Cox at the Duval County Jail. He described Mr. Fucci as intelligent, but without many street smarts.
And you did also review grades and how he was categorized at school. If you'll describe that and perhaps the difference between academics and what you just discussed as intelligence.
Okay, so in school, he was in special education classes. So he was in ESE, which stands for Exceptional Student Education Classes. His designation under that ESE umbrella, there's a lot of different designations. Some refer to designations because of cognitive or intellectual limitations. Some of them refer to limitations because of academic difficulties, which is separate from cognitive intellectual. It's academic. Some of the designations under the ESC umbrella have to do with behavioral issues like emotional handicap. So Mr. Fucci was in special education classes for specific learning disability, acronym SLD. Now, what SLD generally means in the school environment is the student's academic performance is lower than what is expected given his intellectual capacity. So in other words, he's underperforming academically. Okay, so he was in SLD classes and he was recognized as having some academic difficulties. Pretty consistently, he was described in the school environment as struggling academically. Okay, in specific areas, so specific learning disabilities. So specific for Mr. Fucci was language arts, like reading, and math. Those appeared to be his two primary areas of academic difficulty. So you know, he had tutors, he had services in that SLD curricula where he had ESE teachers who would spend individualized time with him. He still struggled in those areas. Now, there was another indication of academic, I would say academic deficiency relative to peers. So there's a Florida standard assessment. It's a standardized academic measure that is given to every student yearly to see where they match up with their peers, their same age peers, in terms of academic performance in a number of different subjects. So Mr. Fucci took these Florida standard assessment each year like all the other students. The scale is basically 1 to 5. 5 is the best, that means mastery, whereas 1 is the worst, which means the term they use is inadequate. Mr. Fucci scored in the 1, the inadequate range, pretty consistently in language arts and in math, and at least one time in science too. So clearly those were some specific problems for him in the academic environment.
And what about his grades? You reference, I believe, kind of starting, I think it went back to 4th grade, and then
right,
how they go over time.
Right. The grades were never great. He had some better years and some worse years. It looked like his worst year was likely the 6th grade. 6th grade, it was a lot of D's and F's, not all D's and F's, but a lot of D's and F's. However, I noted that in 7th and 8th grade, his grades seemed to get a little better. It seemed like maybe at that time he was getting a little more individualized attention in the SLD, exceptional student education context. So his grades in 7th and 8th grades were, a couple of A's, a couple of B's, several C's, 1D, 1F. I think that was 7th grade, and then 8th grade it was similar. So it was kind of all from some A's, at least 1F, but I would say in average, it was probably C average if you averaged all of the grades. So his grades weren't terrible. They weren't good. They were kind of middle of the road, except worse when he was in the 6th grade and seemed to get better. Now, I noted that there was it's called an IEP, standing for Individualized Education Plan. These students that are in the ESE curricula, they are given a individualized education plan so they can map out kind of goals for the student. I noted the last one for Mr. Fucci was put together in April of 2021, which would have been 1 month before the murder. So at that point in time, he was still on track to receive a standard high school diploma. So sometimes when it's obvious that a child is not going to academically be able to achieve to the point to get a standard high school diploma, they will get what's called a special education diploma. In Mr. Fucci's case, his last IEP indicated that he was still on track to receive a standard high school diploma. One other thing that was referenced in that IEP was there's a question on the IEPs: does the child's behavior interfere with his academic achievement or the achievement of other students? So on that last IEP, that question was answered yes. So there was another dimension here with Mr. Fucci, and that dimension is he had some behavioral issues in school as well.
And I want to talk about the behavior in just a minute, but before we get to that, along this line of his ESE and SLD designations, when you reviewed all of the information from the teachers, there was a dean in that mix, I believe, a dean of discipline and the teachers. Did their descriptions of him and his performance, were they consistent with that descriptor of an academic problem versus the actual cognitive intellectual? And explain that a little bit to the court.
Scope of his expertise.
Yes, Your Honor, she's asking questions about education, not as a psychologist or his role.
Repeat your question, please.
No. I'm asking him if the teachers provided any information to support his opinion that Mr. Fucci had more of an academic problem than a cognitive problem.
The objection is overruled.
Yes, it was fairly consistent from the teacher's perspective. And again, there was no reference to him having cognitive deficits. Like Mr. Fucci isn't bright or he's struggling cognitively. The consistent characterization by teachers was that he has the ability and the capacity to achieve academically, but his motivation is lacking. So it was that other component was some behavioral issues, excuse me, some lack of motivation, some lack of effort that was also getting in the way of his
and that's why
performance.
he pushed her.
Okay. And
But he
before I
also
interrupted
said-
there, you were going to move on to the behavior and disciplinary issues that could be playing a part in these grades and things that you saw. Is that right?
Right. It kind of goes hand in hand. When we have students who behaviorally, they're not doing what they're supposed to be doing, they're getting in a lot of trouble, maybe suspensions, then that can affect their academic progress because they're not always listening to the learning that is provided by the teacher or, these grades 1 through all the way through 12th. Each grade builds on the next in terms of skills. So if the student isn't picking it up because their behavior is poor, they're not motivated, then as they progress through school, their academics are usually going to get worse. Okay. So what I noted about Mr. Fucci, in terms of his behavior, in the third grade, his behavior was characterized as pretty good. So he got satisfactory ratings from his teachers in terms of his conduct in essentially every area. Excuse me. By fourth grade, there seemed to be some indication that his behavior was getting a little worse. So there were some characterizations by teachers that he wasn't always motivated to do his best. He wasn't always controlling his conduct. So you saw that a little more in fourth grade. And it seemed to get worse as time went on, which is not unusual. A lot of times with adolescence, with pubescence, when a child gets to be 12, there's hormones and there's different social demands. And sometimes that's when we really see the bad behavior emerge from a child who maybe had demonstrated fairly good behavior before then. So we see that. So I noted that he had between February of 2018. So February of 2018, Mr. Fucci would have been 11 years old. And April of 2021, which again is a month before the murder, and he would have been 14 years old. So in that span of 3 years, he had 22 disciplinary referrals. Okay, so that's a fairly high number in a school environment. Okay, 22 disciplinary referrals. So I noted the nature of the disciplinary referrals. Were they violent? Were they not violent? I noted that 2 were violent, which is not, it's not a real high number of violent incidents, but in May of 2019.
Objection, Your Honor, and we're renewing the previous motion about the prior bad acts.
All right, over objection, you may testify to this, Doctor.
In May of 2019, and again in October of 2019, he had 2 disciplinary referrals for punching another student in the face. I saw a disciplinary referral in March of 2019 where he was referred because he was cheating. He had the math answers on his phone. I saw mostly disciplinary referrals for characterizations of him being disrespectful to teachers, disruptive in the class environment, or just kind of oppositional with teacher demands, and also on the bus. So those disciplinary issues over that span of time resulted in at least 3 out-of-school suspensions and at least 4 in-school suspensions. So that's again between 11 and 14, which he was in 8th when he was in 14. So that would have been going back to about the 6th grade, where behavioral things seem to very likely affect his progress and his academics, which the majority of his teachers recognized and talked about.
How does that compare to, comparing the individual of Aiden Fucci to a group of his peers, juveniles, and what you know about the occurrence of suspensions and things like that?
Right. It's important to know, because in a vacuum, we don't know if that's relevant or not. So, but it's not in a vacuum. So what we know is that individuals in school, juveniles, that's kindergarten through 12th grade, suspensions rates nationally this was 2019, was 5%. So 5% of students got suspended at least one time. That was actually down from a couple of years before that, where it was 7%. But it hovers around that area in the last 10 years or so, where 5, 6, 7% of students get at least one suspension during a year. So the point is, it's unusual. So we can knowledgeably say that Mr. Fucci getting suspended from school is unusual for his group of peers. Relative to his group of peers, it's an unusual thing, and it provides us some information to make some judgments about it.
And then moving on to that mental and emotional health, I think you've already commented on the teachers, but teachers, and then I believe his two closest friends, Sophie and Trey, provided a lot of that insight for you. Is that right?
Yes, that's mental and emotional health. If I may, I'll go back over the teachers a little bit just because I didn't cover everything. So there was some consistency in what teachers related about their experience with Mr. Fucci. And there were some things that were a little bit inconsistent between teachers. The consistent points were teachers said consistently, without exception, he has the ability to understand and comprehend, okay? He seems to understand right from wrong. He seemed to understand there were consequences for inappropriate conduct or not doing your work or whatever. They all were consistent in relating that they had never seen Mr. Fucci appearing that he was responding to voices in his head or making the verbalization that he heard voices in his head. So those are the consistent things amongst teachers, and I think really relevant. It speaks to a lot of things, including, you know, ability to appreciate risks and consequences in general, understanding right from wrong. He knew these things in a general way, according to teachers. Now, some of the inconsistent things between teachers, you know, there was bad and good. One of his ESE teachers that spent a lot of time with him in the 7th grade was Alyssa Gates. And she said Aiden was a pleasure to work with. He worked hard. There was no behavioral issues whatsoever. He did what she asked him to do, seemed to want to do well and achieve. So that's kind of one end of the spectrum from one teacher, whereas other teachers, for example, one of the teachers, you know, described him straight out, said he was a punk. His PE teacher, it was teacher Jay Shepard, said that he was difficult to deal with, said that he was defiant and he would rarely dress out for PE, said that he was aggressive, and gave the example that Mr. Fucci would like plow through kids that were in his way because he wanted to walk where those children were standing. So he just kind of plow through them. Characterized that Mr. Fucci seemed to always want to get in a fight or an altercation, was looking for it. So a little bit of a mixed bag according to what teacher was characterizing their experience with Mr. Fucci in school, and it kind of ran the gamut from quiet and respectful to kind of aggressive and very defiant.
And I believe Miss Gates, she's from his previous school, if you recall that 7th grade. And if you recall the audios that you listened to, which was the large amount of teachers, were those his most recent teachers that law enforcement was interviewing shortly after the murder?
Yes, those are his most recent teachers at Patriot Oaks. You're right. Alyssa Gates was a later deposition, and she had experience with Mr. Fucci at his previous school in the ESE department.
But the 8th grade teachers and the dean and all those that you referenced that were at least more consistent, those were all his current, as of the date of the homicide.
That was, and
teachers.
Right, and a lot of those consistencies that I mentioned, I'll even mention that one of the teachers, Mr. Wetjen, Wetjen, he had known Mr. Fucci for quite a long time and described himself as a mentor to Mr. Fucci. So point being, Mr. Fucci had at least one adult mentor in the school environment that was trying to help him. He said Mr. Fucci would seek him out if he was in trouble, and they would talk about things. So Mr. Fucci seemed to have some, you know, positive people that he could contact in the school environment to help him out if he needed it.
Is that all for the teachers and
I
along
think
those
so.
lines?
Yes,
And then we
yes,
move
ma'am.
on to his peers, Sophie and Trey. And I know there's a lot of information from Sophie that
Right.
law enforcement gathered about him generally, emotional and mental health, close in time to this crime. So he could talk about the things that are of significance to you and your ultimate opinions in this case.
Right. I think a good place to start is with some of the things that were described by girlfriend Zoffie Bowman. Now, just as a context, Zoffie Bowman and Aiden Fucci had been dating since January or February of 2021. So multiple months, spent a lot of time together. Miss Bowman described that she and Mr. Fucci and some other peers, they were kind of into what she described as gore, what she described as horror, HORROR. So they like to watch horror movies. They like to watch gory horror movies. So she commented about that. She also characterized that they all had what she described as dark humor. Okay, so that was part of the context where she disclosed some of this information. She said that she and Mr. Fucci talked a lot about things they saw on these horror shows and gory movies, that a lot of times they would discuss death and killing in the context of these types of movies. Okay. But she went beyond that a bit. And she also described that her words were that Mr. Fucci talked about death and killing a lot. Okay. Now he talked about death and killing a lot. She gave a couple of examples when Mr. Fucci got really mad at her because she sent a picture of her in a photo with another guy that happened to be her sister's boyfriend or friend that was a boy. And she said that Mr. Fucci got extremely upset about this, and his reaction was to say he was going to kill that boy. She also gave an example of Zoffie Bowman asking Mr. Fucci, would you like to hang out with me and a couple of my guy friends? And she said that Mr. Fucci's response to that was to talk about how he was going to kill those two guy friends. So this is important because there was a lot of this killing and death talk from Mr. Fucci that's unusual. And it was occurring outside of just the context of talking about gory movies, right? Sometimes that was the context. Other times it wasn't. Mm-hmm. Like the example of him saying he was going to kill these boys that she was around. In that same theme, she talked about, her words were that Mr. Fucci talked about wanting to kill her, and that he would sometimes do things to her like take his knife out and pretend to stab her, or walk up behind her and pretend to slit her throat. Mm-hmm. Now, she indicated she wasn't scared of this. She wasn't scared of Mr. Fucci because she trusted him with regard to those specific acts. But it was interesting that he would make the comment that he wanted to kill his girlfriend, Zoffie Bowman. She took it as kind of a joke and is not serious. She also made a similar comment that I thought was significant, that Zoffie Bowman said, that's basically why Mr. Fucci no longer stayed at my house, because he talked about how easy it would be to kill me when I slept. So you see, this is going beyond just kind of this talk about gory movies. It's, I'm not sleeping at your house because you would be really easy to kill while you're sleeping. A really, really peculiar, unusual rare kind of comment repeatedly made to one of Mr. Fucci's closest friends. Now, it even goes beyond this. Okay, so this is the thing that is, I think, most relevant, although the things I was talking about are relevant to this particular case, but the most relevant verbalizations by Mr. Fucci in the Tristan Bailey murder was Zoffie Bowman recalled Aiden Fucci telling her that basically asking, what would you do if I really killed somebody? And then following that up with, expect me to kill somebody within this month. So Zoffie Bowman was asked if she could pin the date down. She couldn't exactly pin it down, but she said she believed that remark was made by Mr. Fucci in the month of May of 2021, the same month where the murder occurred. Okay, and when talking about how he would kill, so really it's extensive. It's not just a here and there. It seemed to be a real fascination of his. When he talked about killing somebody, he even told Zoffie Bowman how he would do it. And what he told her was, I would walk around at night and I would find somebody else walking at night. I would drag them in the woods and I would stab them. And then I would pretend like I didn't do it so that I could keep killing people. Now, kind of, again, in a vacuum, that's a weird statement. That's a weird remark, but this isn't in a vacuum. When we examine that statement occurring close to when Tristan Bailey was murdered and how remarkably similar it is, it speaks to me. It speaks to emotional health. First off, it's unusual. I can't stress that enough, how unusual it is for a peer to be talking about this kind of thing so frequently in such detail with such gore. It's pretty bizarre. And to actually carry it out, because that's the other thing. We compare Mr. Fucci to his population, other juveniles. Juveniles sometimes make violent remarks. Juveniles sometimes talk about violent fantasies. It isn't something that usually kind of predominates what they verbalize, or is a fascination like it seemed to be with Mr. Fucci. But to get as specific as Mr. Fucci got in terms of talking with Zoffie Bowman about the things he was thinking, I think it really suggests to me that he's giving a glimpse of what he's thinking about, what he's fantasizing about. She even said that she believed he was just talking about a fantasy. But even so, fantasy is rehearsal. Often it's a rehearsal of what we want to do or what we're interested in. So there seemed to be a lot of that going on with Mr. Fucci preceding the murder of Tristan Bailey. And it's different because he actually carried it out. Okay, he carried out that fantasy. He just didn't verbalize it. He verbalized what he'd like to do and that he would do it soon, and he actually did it, which suggests some rehearsing of that very kind of instance with Tristan Bailey.
Is that sort of verbalization and all the different pieces of evidence that you have that point to that thought process, is that even unusual amongst juveniles that commit violent acts?
It is. It's very unusual. And again, it's not that uncommon for juveniles to talk about something violent occasionally or get in a fight occasionally, but to talk about death and dying in almost a preoccupied way, it's extremely, extremely unusual. And that violent, not punching somebody in the face, stabbing somebody. He also made the comments to his best friend, Trey Absher, that I'll talk about next in that same vein.
And before we move on to Trey, when you were originally talking about how some of the context of these comments were in sort of a shared interest of watching horror movies with Sophie, his girlfriend. Did she explain, though, a difference between what she was interested in and what Mr. Fucci was interested in that respect?
Yes, thank you for reminding me of that. Yeah, so that was an interesting thing too. So Zoffie Bowman made it clear, I like gore and horror, but it was fictional. It wasn't real. It was a movie. It was pretend, right? But she said that she commented about Mr. Fucci actually pulling up videos off the internet that were real life gore videos. So they're out there. So real life gore videos of, she said, somebody getting his head chopped off or somebody getting shot. And that was a distinction she made. She said, yeah, I like gore, but it's fictional and fake. Whereas he seemed to look for the real life, not TV stuff. And he enjoyed looking at that.
Sophie had also witnessed Mr. Fucci outside of herself commit a violent act or be in a fight, I believe, as well, close in time.
She talked about seeing him violent when he beat up another kid at a food truck one Friday night, basically stole his vape pen. Mr. Fucci stole the kid's vape pen, and the child wanted it back, and Mr. Fucci beat up the child.
And when he described the type of people he wanted to kill, do you recall what Sophie indicated the type of people, whether they were people he liked or didn't like?
Well, he said he wanted to kill people he liked. And she specifically referenced in that case that he kind of pulled that from a horror movie. He related to that line in the horror movie of killing somebody you like. She also indicated that he typically talked about killing other guys, less so about girls, more about guys.
Okay. And then what information, if any, did his closest best friend, Trey Absher, have consistent or inconsistent with Sophie?
I mean, it's more of the same thing. So I think one of the differences in Trey Absher in terms of what Mr. Fucci verbalized to him is the statement, it would be satisfying to slit somebody's throat, and the statement, it would be satisfying to watch the blood drain out. Now, really unusual for anybody to make those remarks as that satisfying, right? What was interesting is Trey Absher had a response that I thought represented what is within the realm of normal, a normal response to these remarks by Mr. Fucci. So I think it would be satisfying to slit somebody's throat. I think it would be satisfying to watch the blood drain out. Trey Absher's remark was, it was weird and not normal. And he even said that I can't imagine stabbing somebody like that, especially repeatedly. Okay, so it's interesting to think about. That's a normal response. Most of us can't imagine doing this harm to another person, especially in such violent and close-up way. And that was Trey's experience of those remarks. But Mr. Fucci didn't seem to have any compunction to make those remarks and understand, the effect it had on even his friend.
Dr. Pritchard, kind of moving into the information
He's
you
much
gathered
worse than I
about
thought.
Mr. Fucci's general background, his
Yeah.
family, home, and community. What of significance
No wonder they
did you
wanted
note
this
was
kept out.
present and not present about Mr. Fucci's background that ultimately adds to some of the opinions you give in this case?
Right. So this was a little bit of a mixed bag too, depending on who you asked. So I'll go with Zoffie Bowman and Trey Absher first, peers. So Zoffie Bowman in particular talked about Mr. Fucci telling her that things were really difficult at home, that he did not feel very loved or appreciated by his parents. He felt like he was the least important and least liked out of all the family. Zoffie Bowman also said that Mr. Fucci described that his biological father, Jason Fucci, was sometimes physically abusive. She chronicled 4 specific incidents where Mr. Fucci told her that dad choked him one time, slapped him one time, and punched him 2 times. So 4 separate incidents of what she described as Mr. Fucci saying Jason Fucci was physically abusive towards him. She also described that mother was not a very good mother figure. She went so far as to say that Mr. Fucci described what she believed was emotional abuse in the home from mother. She related that she had urged Mr. Fucci to report it. She was concerned enough to say, you need to report this. This is emotional abuse. As time went on, she dropped that idea because Mr. Fucci didn't seem very responsive to her concern about emotional abuse in the home. So those were the suggestions from peers that some things were going on at home that were less than healthy. Now the siblings of Mr. Fucci, and that would be Dylan Hicks and that would be Preston Fucci, did not characterize that there was any abuse in the home. Okay. In fact, Dylan Hicks described Jason Fucci as a fantastic father, as a very good father figure who was basically always there for him. Characterized a different kind of discipline than Zoffie Bowman indicated Mr. Fucci told her, and the discipline was essentially he got spanked on the butt by Jason Fucci if he did something wrong. Also, that discipline in the home involved go to your room, not being able to have contact with your peers, or taking away your cell phone. So obviously a very different characterization from Zoffie Bowman suggesting that Mr. Fucci said that Jason in particular was physically abusive and mom was emotionally abusive. Grandmother, Deborah Spywak, that's maternal grandmother of Mr. Fucci. She's been in the home a lot. She used to live there during the week, had another home, and that's where she'd go during the weekend, but spent a great deal of time with Aiden Fucci and the family. She didn't characterize that there were any problems in the home at all. She essentially said that everybody got along well, that Jason Fucci was a fantastic father, that Michael Akel, stepdad, was a fantastic father, that Crystal Smith, Deborah Spywak's own daughter, was a wonderful mother. She said that since the split of Mr. Fucci's biological parents, so blended family, 2 different households, that neither parent had ever missed one of their prescribed weekends that they had custody of Aiden and his siblings. So she described it was very positive, that everybody worked hard, that it was very conscientious parenting, that the children had all they needed and wanted. She described them as spoiled kids, in fact. She described herself as very close to Aiden Fucci. So again, a little bit of a mixed bag. Most of the people in the home, other than Aiden Fucci, were describing what I would say is fairly normal existence in that home. Whereas what came from Zoffie Bowman, which is what came from Aiden Fucci, was there were some incidents of perhaps physical abuse in the home, and what Zoffie Bowman perceived in the description from Aiden Fucci to be emotional abuse from mother.
And again, comparing this individual to similar peers and in the criminal justice system, juveniles that you've looked at, how did his background sort of compare to other backgrounds that you witness and see that contribute to behaviors and things?
I mean, I would say, relatively speaking, he had a very good background. Of course, in the criminal realm, we see a lot of poverty often. We see a lot of abuse. We see a lot of drug addiction. There was also commentary that Mr. Fucci's parents didn't use alcohol or drugs. So I would say he had a very good upbringing, relatively speaking. We didn't see any of that clear dysfunction that you often see in criminal cases. We didn't see poverty. We saw a picture of the house earlier.
Yeah.
At least I would say middle-class family, middle-class household. A lot of people interested, grandmother, biological father, stepmom, biological mom, stepdad, siblings. So a lot of people interested in Mr. Fucci and his sibling and his family's lives, which is also sometimes not seen in the criminal context. So I would say, relatively speaking, it was pretty unremarkable, pretty normal, existence for him.
Okay. And then moving on to one of the other larger categories of factors that you considered. Talk about what you learned through the records and how that relates to the effect of any immaturity, impetuosity, failure to appreciate risks and consequences. And obviously the importance of this is how all that relates to his participation in the offense.
Right, participation in the offense. So I've talked about immaturity. The important thing.
I got somebody at the door. I'll be right back.
He's 14 and a half. So he's immature relative to an older population. Okay, so all 14-year-olds are relative to young adults or older adolescents, but relative to his peers, no description of him being immature. Immaturity related to the crime, it's so unusual. The behavior is so unusual in this case, for a 14-and-a-half-year-old, that it's hard to know if immaturity played any role whatsoever. I can't really offer an opinion on that beyond what I've already said.
What about impetuosity?
Impetuosity, I would pull in what I would describe as fantasies, the pre-existing experience of violent fantasies in Mr. Fucci's head that he verbalized to peers that were very descriptive, that were very similar to what happened to Tristan Bailey. I would say that suggests to me some rehearsal, perhaps some premeditation. And when I say perhaps some premeditation, when he says, expect me to kill somebody this month, and he's already kind of outlined how he would do it, it seems like he had some rehearsal of that in his head before it occurred. And so that was important. Okay. It suggests the opposite of impetuosity. So if you're planning it and thinking about it fairly extensively before it occurs, it's not impetuous, that's more planned. Okay, he even made that comment to Zoffie Bowman. If he does it, it's going to be planned. Okay, so that's one aspect of it. The other aspect of it, I would say, and a really important one, is the actual crime. Okay, so these terms, impetuosity, okay, what does that really mean? Well, impetuosity, impulsivity, lack of forethought, where you just kind of do something and you don't think about it and you don't think about the consequences. It's essentially what it means in this context. So the crime, and I would like to illustrate my point with a hypothetical, if I may.
Yes.
Okay,
I'm
so
objecting, Your Honor, there's no question being posed.
I can pose a question. Again, the court has heard the facts, and I know you'll weave them into your answer about the nature of this crime.
Right.
If you were to compare the nature of the crime itself that Aiden Fucci committed to the larger group of his peers and juveniles that commit violence. Why is it that you call this particular act not impetuous? And what is an example of one that would be?
Okay, so in terms of what is an example of one that would be, that I've seen in my own experience.
Sorry, an objection again, Your Honor. So now he's describing the nature of a crime. He's here qualified as an expert in psychology, not in crime scene, or even in detailing the nature of a crime. So I'm objecting to this line of questioning.
All right, she's going to repeat her objection.
And I apologize. Defense is objecting to the line of questioning. Dr. Pritchett has been qualified before the court as a psychologist, not a crime scene expert or in the nature of homicides. So to this question and this line of questioning, defense counsel is objecting.
Your Honor, the issue of impetuosity is one of the most important factors within the factors. It's one that Dr. Bloomfield is going to testify about as well. And the doctor is clearly qualified and has a lot of experience in seeing juvenile crimes and the varying types of those crimes. So he's simply trying to describe why he believes this one is not an impetuous act. And an example of what an impetuous act would be is describing impetuousness within juveniles or within criminals and the differences between categorizing something as non-impetuous and impetuous.
Right, the objection is overruled. Doctor, you remember the question?
Yes, Your Honor.
You may answer it.
Thank you. So the example of to illustrate of what I would consider impetuous crime. For example, a youth goes into a convenience store with a gun with an intent to rob the clerk. The clerk reaches under the counter and the youth fires the gun and hits the clerk and runs out of the store. Okay, so impetuous meaning there's no indication that youth had plans to shoot the clerk. Okay, there's indication that it was kind of an immediate reaction. Maybe believed he might be shot, so he pulled the gun. So I would say that would be a good example of likely impetuosity or impulsivity. Now, to change a few of the dynamics in that hypothetical, okay, that same youth goes into the convenience store with a gun to rob the clerk. The clerk gives money to the youth with the gun and is not armed. There's no firearm under the thing. So he gets the money and the youth takes the money and then shoots the clerk. And then he walks over to the counter and shoots the clerk 20 more times while the clerk is lying on the ground. So you see in those two different examples, impetuosity in the first one, impulsive, we don't know intent to really do anything when he entered the store, versus the second example where there seems to be clear intent. So clear thought and plan to shoot the clerk, whether he got the money or not, to kill the clerk. Don't shoot him once, you go over and you shoot him 20 times. So it seems far less impetuous and impulsive than the first example. And I would say that's a good direct comparison to the Aiden Fucci case. Okay. So.
And why in this overall realm of Miller-Graham considerations, opinions, psychology, everything that came out of those cases, why is that factor so important?
It's so important because that's why these juvenile sentencing laws came into effect, because youth are typically impetuous or can be impetuous relative to adults. There's no question juveniles are different than adults, and we have to consider that. So they can be impetuous. They can do something without giving it much thought that can affect their life forever and the lives of others forever. And we have to consider. So that's why we have to kind of analyze it to see, does it look impetuous in this case or does it not look impetuous? Okay, so that's why it's relevant.
And that's why it's important to look at the individual, all these factors we've gone through, and the act itself, right?
Yes, you always have to look at the individual. Every forensic case, you're looking at an individual. You're not evaluating a group. I was asked to evaluate Aiden Fucci, not a group. But that being said, when you evaluate an individual in a forensic context, you're making comparisons to the group that he comes from. That's the comparison sample. So as I said, these things aren't in a vacuum. How do I know that suspensions matter? Okay, I know they matter because it's unusual for his peer group. So I can say Mr. Fucci as an individual is unusual in the sense that he gets suspended, whereas 95% of his peers do not. And that's kind of how we go about it. So I want to compare him in all the things I'm talking about. The context and the comparative sample is his peer group, juveniles.
And under that same factor, again, I believe there was one other consideration we've talked about into this impetuous analyzation, fantasies, the nature of the crime. You also mentioned your report cover-up. How does that play a part?
Yeah, so cover-up, I didn't really talk about how it was a protracted crime. It was a long crime.
Right.
Relatively speaking. So in the example I gave, go in, shoot, leave, takes a second or two maybe, versus go in, rob, shoot once, shoot 20 more times. It takes a lot longer relative to the first example. So in this crime with Mr. Fucci, his inflicting 114 wounds, it takes a long time. It doesn't speak to impetuosity to take that long. There's thought going on in his head as this is playing out. How long exactly did it play out for? We don't know. Let's say a couple minutes.
Objection, Your Honor, speculation.
For 114 stab wounds versus 1 or 2 seconds in the impetuous example I gave. Had Mr. Fucci stabbed Tristan Bailey once or twice, impetuous, impulsive, probably. 114, I think you really would have a problem making that argument legitimately.
Even if you didn't have that premeditated fantasy information, the crime itself speaks to that, right?
Exactly. Even if you didn't have that premeditation, although I would say clearly he did. Clearly it's there. It's in his head beforehand. So then the final thing would be the cover-up. Okay. So that this really plays to appreciation of risks and consequences. All right. So cover up. When somebody tries to cover up a crime, the implication is they understand the risks and potential consequences of that crime. And their effort is to not get caught because they recognize it's wrong. Okay. It all plays into that. So in Mr. Fucci's case, the cover up would be getting rid of the murder weapon, probably not too long after the crime occurred. We don't know how long, but it was in the retention pond right near her body. So he got rid of the murder weapon. Okay, so murder weapon, immediately get rid of it because he recognizes that he doesn't want to have that, or else he'd be caught and implicated, and he doesn't want to be implicated. Same for all other aspects of cover-up, hiding the shoes behind the bureau, hiding the T-shirt under the bureau, lying to people. So lying to Zoffie Bowman and Trey about what happened to Tristan before the body was discovered, lying to his parents when they were talking to him in the interview room, lying to authorities about what occurred. So why do we lie? We lie because we don't want to get caught, because we know we've done something wrong. So it's appreciation of potential consequences that you don't want for yourself. And that's what generates the behavior. So it seems to be clear indication that he's appreciating that related to his case with that cover-up behavior.
Okay. And that blended into factor I, which was the any effect of his characteristics of youth on his judgment. So you sort of outlined that he was able to think through and cover up evidence, at least in his manner. Is that right?
Yeah, it's yeah, the effect of his youth on his judgment. So the judgment to kill Tristan Bailey, is that related to his youth? I don't know how anybody could say it is or it isn't. I don't know. That's hard to identify, but he was obviously demonstrating judgment throughout that. Judgment in terms of, the stab wounds, a number of stab wounds.
Right.
The cover-up, that's judgment. Excuse me. So clearly demonstrating judgment, but how much that judgment related to the decision to kill Tristan Bailey is related to his youth. Again, it's a really unusual act. This murder is really unusual. I don't know how you could say it's related to his youth or not.
And when you give that opinion, do you have some, again, statistics of the group, the juvenile group, to sort of compare him to on violent acts?
Well, yeah, on violent acts, yes. So just generally violent acts committed by juveniles. So the entire group of juveniles who commit criminal acts, violent acts are about 7% of those criminal acts. So it's a small percent. I'm sorry, that's incorrect. Okay. So of all the violent acts, 7% are murders. Okay, so it's unusual. So murder by juveniles, all the violent acts, only 7% are murders. So it's unusual. Now that's
Your Honor, again, now he's talking statistics and he's being called as a psychologist.
I'll sustain the objection unless you have something to cite.
I provided it to, I think, both counsels.
Dr. Pritchard, you did. You provided a
We do have a copy, Your Honor, but it's from the criminal.
From the
it's
US.
a federal organization, and it's not APA or the Association of Psychiatrists and Psychologists.
Let me make the link.
The objection's overruled.
So yes, it's unusual.
Okay. And again, why it's relevant to your work in this case is what? What are you looking at in making recommendations and opinions to this court about this defendant? Are you looking at all juveniles? Or are you looking at Aiden Fucci?
I'm looking at Aiden Fucci, but I'm comparing him again to all juveniles. That's the reference sample. And we have to see, is Aiden Fucci, is there anything about him that's different as an individual based on what we know about other juveniles and what's normative or normal behavior with those juveniles?
Okay. And all of that is, again, comes out of, as you're aware, the Miller and Graham decisions and why courts, and especially in Florida, court has discretion here. So the court is to look at the individual, and you're here to provide insight and compare him to other similarly situated juveniles. Is that fair?
That's correct. That's fair.
There's two very brief factors, brief comment you probably have on those that the court's to consider. The extent, it's F and G, the extent of his participation in the offense and any pressure on him by outside peers in this case. So did you see any evidence of anyone else's involvement or influence on Aiden Fucci in this case?
Nobody else's involvement appears that he acted alone or that anybody influenced him, either peers or family.
One of the last sections you discuss in your report is the possibility of rehabilitating the defendant. And there's some different information in addition to the rest that you talk about in that section. So if you would kind of talk about your opinion on that and then what that opinion is based on.
Right, so the possibility of rehabilitating the defendant, a lot of times the best information to get on this variable comes from after the crime occurred, when they're incarcerated. How are they doing? How are they adjusting? Are they demonstrating things clinically that we would like to see, like some compassion and some sorrow and what went wrong and how can I, do things better. And I feel so bad for the family, anything like that. Or do we see things that are more negative that doesn't really speak to the person trying to get better, or maybe even recognizing or acknowledging or taking responsibility for what they've done? So in Mr. Fucci's case, the information comes from Duval County Jail, where there's commentary, and I got much of this or some of this from the deposition from Sergeant Cox there at the jail. Sergeant Cox's deposition talked about how Mr. Fucci had been functioning in the jail. One of the things that Sergeant Cox indicated that
Your
Mr.
Honor, we would renew the objection regarding the new acts without any conviction that were cleared by the same paperwork.
The objection is overruled.
Can I repeat that for the?
You may.
Defense renews the objection for the post-arrest acts, bad acts without a conviction, that he was cleared in the same paperwork that Dr. Pritchett is now relying on, or at least moving forward with this session.
The objection is overruled.
Go ahead, Doctor.
Right. So the general indication from Sergeant Cox was that since Mr. Fucci has been in the jail, he has been given opportunity to be in the general population at the jail. And I guess I should say that at the jail, he's housed with other juveniles who are direct filed. So these are other juveniles who have serious charges. They're not with adults. So it's another juvenile population, but is in the adult jail. Had opportunity in the general population, but according to Sergeant Cox, it's never worked out for Mr. Fucci because of his own behavior. See, the benefit of being in general population is you get to come out of your cell 8 hours per day and socialize and, play games and watch TV. Whereas other places that they are housed, if their behavior is not good, they don't get those level of privileges. So Sergeant Cox described Mr. Fucci being able to make it in the general population very well because he always gets sent back to administrative confinement or disciplinary confinement or seclusion because of something he has done. He mentioned some of the things that Mr. Fucci had been doing in the Duval County Jail that resulted in him not being able to stay in the general population. And essentially, one of the main things was he was extorting commissary. So commissary that he gets, all the inmates get, snacks and things. He was extorting the commissary from smaller juveniles at the jail. When asked about how this extortion was taking place, essentially Sergeant Cox was characterizing that Mr. Fucci would make threats like, if you don't give me your commissary, I'm going to ask them to put you in my cell. So it's kind of an implied threat there. Sometimes was explicit as threatening to harm or kill the other inmate if he did not give the commissary to Mr. Fucci. It happened to at least two additional inmates there early on, and then it sounded like it happened to two additional ones with different initials later on, where he was extorting the commissary. There were a couple of complaints by other inmates that Mr. Fucci was threatening them. I'm going to kill you. I'm going to kill your people. Was threatening to stab them. There was one indication by Sergeant Cox. He provided a, if I may refer to my report real quick and find the actual quote.
I think 17, paragraph 2, maybe. 1 or
Yes.
2.
So one of the specific quotes was attributed to Mr. Fucci toward another juvenile. When I go to general population or when I get a chance, I'm going to stab you and I can't wait. I'm going to look you straight in the eye. Right. And so these really explicit, again, unusual comments. So doing this extortion, doing these threats, manipulating, kind of bullying to get things he wanted, and even referencing his case in the process of threatening or trying to extort. So the idea being that Mr. Fucci seemed to be using the incident, and that is the murder and the characteristics of that murder, to exploit and to get what he wants in the jail environment. Okay, and in the absence of, it's really callous to make those statements. Most of us see that. It's callous to make those statements that, I'm going to stab you like he did to Tristan Bailey. So it's, there's concern for me clinically that he is not demonstrating any kind of compassion, any kind of understanding, and maybe he can't understand what he's caused, the terrible, terrible situation he has caused for so many people, Tristan Bailey's family, the community, his own family. So really a real void in terms of demonstrating some conscience, some understanding that this was terrible and expressing any kind of sorrow for it.
And closer in time to the actual murder, you had a few more pieces of evidence of insight to him. You had the Snapchat videos and then the interaction with his parents. Did you see anything in that evidence that would relate to his ability to be rehabilitated and just his general reaction to the crime and how that applies?
So again, it's just the unusual, incredible callousness about his behavior in the back of the police car. Okay, that's really, really unusual, and it does not suggest clinically that this child, Mr. Fucci, has the same kind of makeup that most of us do and moral compass that most of us do. Okay, so it's exceptionally callous. At that point, he was the only person on the planet that knew where Tristan Bailey was and her status as deceased. And he's laughing and joking and peace sign. And has anybody seen Tristan lately? So really, really callous and concerning. He actually seemed to be having a good time with Trey in the back of the police car. Didn't seem to be that nervous with his parents either when he was speaking to them. So he's got this emotional makeup that for me would be clinically very concerning. And for me would suggest that he doesn't have, I would say at this point, I don't see him as a good candidate for prognosis. He's not demonstrating what I would like to see clinically to say, yeah, we have some hope for this guy getting better. He's not demonstrating that. So I would say that at this point, his prognosis is poor for rehabilitation.
And Doctor, overall, these post-Graham-Miller factors, the 10 that we have sort of covered today, or primarily the 9 that I've gone over with you, the goal of those is to sort of analyze the individual, the crime, give the court some guidance as to how to sentence this particular juvenile. Are they unique in stature, or are we just talking about a general impetuous juvenile? Any final thoughts, additional thoughts, and ultimately your opinion on that in this case?
I would just say that the overall thought for me is that he's a really unique person. I would say in a bad way. He's demonstrating some things that I think are extremely clinically concerning that we usually do not see in youth, that often we don't see in youth murders. So I would say that, again, his ability to kind of grow out of this, maybe, but he's also got some personality things that are really concerning.
Thank you, Your Honor. No more questions.
Your Honor, could we just have a 5-minute break?
Take a 5-minute recess. I'll get 10 minutes till 4.
Since they're going to do a break, we're going to change over real quick. It's been kind of quiet.
We're asking you hypotheticals, and we're asking you, what your thoughts are. And that's why it's difficult. It's really difficult to pick a jury, because I can't come out and say, hey, here's my facts, here's the law, what do you think? You'd make a fine juror. I can't do that. And so you're the only one who can tell us. I'd like you to think about it. And if my time is out, maybe you can tell someone else what your thought process is. But if you do come to a solution on that, raise your hand, I'll come back to you, okay? Betcha. Juror 69, how are you doing over there? Yeah, that's what I'm calling on. Yeah, well, tell me what you think. What do you say?
So this is Josh Cellini talking to the witnesses now, the defense attorney. I said witnesses. I meant prospective jurors.
Seven and a half years of school. What am I going to do?
Big decision.
I don't know what they're doing with the audio. It just kept going in and out. Oh, life. Absolutely life for Aiden Fucci. That kid is a repeat
And I
offender
just want to
waiting to happen.
clear up for everybody. The fact that she's pled not guilty by reason of insanity doesn't take our burden away for the charges. We still have to prove beyond a reasonable doubt that first the crimes were committed. We also have to prove beyond a reasonable doubt, if those crimes were committed, that she was legally sane at the time she committed the crimes. But I mean, are you okay with that burden being?
Crafts, are you talking about Fucci and not Stauch? If you're talking about Stauch, same thing. Put her in there for life. It's pretty black and white for me. And the reason I think we should do the Fucci trial tomorrow is a couple of reasons. Number one, it's the last day, I believe. I believe it's the last day. They're going to have victim impacts. They're going to have the sentencing. Hopefully they get that all in tomorrow. And then what we're listening to now has been going in and out all day. But not just that, it's the same thing we've listened to for the last 2 days. So it's kind of like, okay, let's switch it up. Do y'all agree? Are y'all good with that? I think they will, Amanda. I think they will have a clear, concise case because the affidavit alone, I mean, if that's just a piece of the puzzle, that was so huge. She's gotten interested in the mean kid. Dee'll be here because she doesn't like bullies. I know, right? Kraft says she saw a report that Fucci's parents will not support him or any money for extra. Wow. Hey, show poodles. You been in the background all day? I saw you up here a little bit earlier. What do you guys think about his parents? I mean, do you think that it's true what that they were saying that because you hear two sides of it. You hear what his girlfriend said, which could be from what Aiden make her think, or do you think it's more like what the children in the household and the grandmother said? I'm leaning towards the latter. No, they're not there, Teresa. The parents did not come to court. That little boy has nobody behind him. But you know what? Maybe they realize he's a little spawn of Satan. Well, I'm going to go back since we can't hear what's going on over here in this case. Let's just click back over to the Stauch case and we'll get off this one. Cuz this is getting on my nerves, them cutting in and out. Take that off. And then when they come back, we'll be. I guess defense is going to question him, this doctor, I would think. Yeah, that is sad. How many do we know how many siblings he had? I know that they were younger because I remember when I saw that video they had of the mom trying to clean his jeans. There were a bunch of kids' toys laying around the upstairs room, like it was like a huge playroom. So I kind of wonder if the family dynamic is that Aiden is the only one with his Aiden is the oldest of all of them, and or is Aiden the only child with his biological father and the other two are with his stepfather? Two, from what she can tell in reports. I bet it won't be if I try to wiki it. I bet I won't be able to find it. Ooh, y'all want to hear what the U.S. Sun has to say about his family not being there? It says the teen who is being tried as an adult in connection with the 2021 unaliving of his classmate Tristan Bailey began his sentence hearing on the 21st, yesterday. On Saturday, June 5th, the St. Johns County Sheriff's Office announced Fucci's mother, Crystal, 35, was arrested for allegedly tampering with evidence. We have video of her taking the clothes and trying to wash them. Police said Crystal surrendered herself to the custody of the St. Johns County Sheriff's Office. After then, the 14-year-old Fucci was questioned by investigators. Crystal was reportedly spotted on surveillance video in her home washing her son's jeans, and the arrest warrants, well, that's what the arrest warrant stated. Officers confiscated the jeans, which later tested positive for blood. So they did get something off the genes. I was thinking they didn't. Hang on. On August 24th, the state attorney's office released the surveillance video along with his Snapchat videos that he did in the back of the police car. And then his father, Jason, has also been in trouble with the law before. Oh, I didn't know that. It was reported back in January 2003 he was accused of child abuse, injury, and neglect. That same year in October, he was also arrested for engaging in um, starts with an X. I mean, starts with an S, ends with an X. Activity with a 15-year-old girl at his home. What? Okay, I didn't know any of this. In 2004, he was found guilty of child abuse charges and was sentenced to 1 year and 2 months in prison. Jason was also found guilty of engaging in that with the 2 years of probation. He was only sentenced to 2 years probation for that. In 2016, Jason, Aiden's father, was then arrested again for battery following a fight at a gas station with a couple while his son was present. It's unknown at this time if the defense will use Fucci's childhood in their case. Sounds like he was, yeah, it's like the apple from the falling from the tree. You know what I'm saying, guys? Y'all know what I'm saying? That apple's right there underneath that tree. Okay. They're coming back in. Oh, no. I think that's the. Hang on. Let me turn this off. I'm leaving the other webinar, guys.
So just
They just came back on.
I'll be seated, thank you.
Okay.
All right, back on the record, yeah,
Can I just ask a tiny question before we continue?
okay.
Just to make some decisions. Miss Peoples said 15 minutes, so let's give her 30 minutes. Essentially, I just want to know when Your Honor wants to stop for the day so we can make some decisions, because we would be moving next into family after that, or we could pick that up in the morning. I'm just trying to, does Your Honor want to be done 4:30 or 5?
How many witnesses do you have, or family impact, victim
We
impact
have-
statements do you have left?
We plan to present 6 family members and members from the community. Depending on if we go today or tomorrow, it'll depend on who's here. We're not getting to all of that today, is
No,
my
we're
point. We could start and go into tomorrow, or depending on the breaking time. So I was just,
We'll plan to go till 5 o'clock or so.
okay, and then we'll just see.
Then address, I'm sorry, because we had just filed a motion regarding the victim impact.
Let's finish with this
Let's-
witness.
yeah,
We'll
just-
move into your motion, and then we'll see where we're at.
All right, thank you.
I did receive your motion, I just saw it.
Thank you.
All right, you may proceed to cross.
Dr. Pritchard, good afternoon.
Good afternoon.
So I have received your CV. We're not going to go through all of it today, but in your past, you were a senior psychologist with the Florida State Hospital.
Yes, ma'am.
All right. And part of your work there, Florida State Hospital and with juveniles in Apalachicola. So you've 2 different locations, but you've worked with the state in different locations.
Yes, ma'am, but Florida State Hospital was not juveniles; those were adults. The Apalachicola Forest Youth Camp is juveniles.
Right. So Chattahoochee with adults, Apalachicola with children.
Yes, ma'am.
All right. And you've evaluated, fair to say, countless individuals for Baker Acts.
Yes.
All right. And a Baker Act's a form of civil commitment.
Yes, ma'am.
And a person is Baker acted if they're likely to suffer from neglect or post or harm to themselves. There's a laundry list, but in a nutshell.
Right. Harm to self or others, or will suffer from neglect. Yes.
All right. And a person who cuts himself, they may be depressed.
Yes, they may be depressed.
All right. There could be other reasons, but that could be one of them.
Yes, ma'am.
All right. And a person who neglects to is depressed.
Yes, it could be.
All right. And a person who doesn't change their clothes, again, could be depressed. Not
Yeah.
caring for themselves in general.
Right. You're speaking to kind of hygiene issues, and we do see that sometimes, yes, in people who are depressed.
And some people who are depressed are also suicidal.
Yes.
All right. And a person who's experiencing, for example, delusions or hallucinations, they may be suffering or under the influence of illicit drugs.
That can happen, yes.
All right. And sometimes individuals are experiencing delusions or hallucinations and disorganized speech. Again, could be too much alcohol, too much drug use.
Yes.
All right. Is it fair to say that also an individual who's experiencing delusions, hallucinations, disorganized speech, and I know there are more to that list, could also be experiencing symptoms of schizophrenia per se if they had that ongoing for a few months, maybe 6?
Yes, it could represent what you're describing, delusions, hallucinations. It's psychotic experience, disorganization also. So yes, those are some of the characteristics that can be seen in schizophrenia.
All right. Now, regarding adolescent brain, the brain development is not complete until the mid-20s.
That is scientific fact, yes.
All right. Not up for debate.
Right.
Okay. And an adolescent tends to use the part of the brain that's more emotional, more impulsive.
Yes, that's part of the aspect of the not fully developed brain is they tend to be more impulsive and more emotionally driven and don't think things through very well.
And that's characteristics of children.
Right, it's characteristic of characteristic of all children on the planet who have not, their brains haven't fully developed yet, mid-20s or so. So yes, it's typically a characteristic of children.
And unlike a child, an adult brain developed, or an adult brain that is developed, it'll have the adult brain that is greater cognitive control, meaning an ability to weigh out a risk.
That's true.
Okay. And an adolescent, as they grow, that prefrontal cortex or that area of the frontal lobe will start to mature.
Yes, that's the last part of the brain to mature, but yes, it keeps maturing up through late adolescence and into early adulthood.
And unlike a child, an adult with a mature prefrontal cortex will reason better, develop more impulse control, and just make better judgments. Is that fair?
Well, in theory, there's a lot of adults who don't
Yes.
do that, but yes, that's the idea is when the prefrontal cortex is fully developed, that tends to lend to better reasoning and better judgment, less impulsivity, better able to project risks and consequences, that type of thing.
And that ability or that final formation of that part of the brain is mid-20s.
Yes.
Okay. Granted, as you said earlier, there's some adults never really get there.
Right.
Okay. But children, they're not there at all.
Yeah, they don't have the fully developed brain, so they are not there. It doesn't mean that all children have bad judgments, because some don't at all, but they are more at risk of that because of that not fully formed prefrontal cortex.
Now, is it also fair to say that I heard what you said, but children then lack self-control, or impulse control is the word I should say?
That's one of the risks, yes. And again, all kids aren't impulsive. It's kind of on a spectrum. So, but they're more at risk of being more impulsive as children because their brains aren't fully developed.
And on that same line, then they're not making well-reasoned judgments.
They're not making judgments that are consistent with as it will be for them when their brain's fully developed.
All right. Is cutting a form of self-injury?
Yes.
And is cutting a form of self-injury that can have several motivations?
Yes.
Okay. And is it a common reason, not the only, but a common reason that individuals will cut to distract from emotional pain?
Yes, that
Okay.
is one of the dynamics involved in cutting behavior sometimes.
Right. And is it also, again, not the only, but a common reason that some individuals are cutting to distract from the emotional pain because the intensity of the physical pain will distract from that emotion that they don't want to deal with?
Yes, that's the idea.
All right. Now, is it fair to describe middle schoolers that are participating in drug use as risky behavior?
Yes, that's fair.
Is it fair to describe middle schoolers that are participating in group sex as risky behavior?
Yes.
All right. And is it fair to describe middle schoolers that are not, as a group, because kids tend to work together in groups, that are not listening or obeying their parents on some simple rules, like stay home, would be, again, risky behavior?
Yes,
Now, you did not evaluate Aiden.
that's correct.
All right. And you're a trained psychologist, and you did not administer any psychological evaluations on Aiden.
Right, I can't if I don't see him. So.
Right. You didn't see him, you didn't evaluate him.
Right.
All right then. And with that same line then, you didn't give any specific test in terms of testing for his executive functioning.
I didn't know.
All right. And in terms of Aiden's intellectual functioning, you didn't give any specific test for that.
That's correct.
And then you did receive a large number of school records, correct?
Yes, a
Right.
lot of pages.
And within that large body of school records, you didn't see any psychological tests that were administered to Aiden Fucci.
I did not. I didn't see a single one.
All right. And within those school records, his IQ in relation to the response or the result of a test was not present.
Right. I did not see that any formal IQ testing was done with Mr. Fucci in school.
So today you don't know if Aiden's verbal versus his nonverbal IQ, what those numbers would be.
I can't say.
And if there's a difference between Aiden's full scale IQ and predicted IQ, again, you have no ability to opine on that.
No, not really even having talked to Aiden at all. If I talked to him, I could probably give an impression, but I wasn't able to talk to him.
Now, in school, and I'm not asking you line and page, but fair to say that on several of the school years, he was scoring 1s and 2s on the FSAs.
Yes, I mean, it was real consistent in language arts and math, as I indicated. I think it was grade 3, 4, 5 on up, maybe once in science. Sometimes he scored 2s. I never saw him score 3 or higher on that Florida Standard Assessment.
And by the time he's in 8th grade, he's not reading. Well, it's not 8th grade, but for the majority of his school years, he wasn't reading at grade level.
No, I mean, the last IEP when he was in 8th grade that was in April of 2021 indicated he was reading at the 6th grade level. So it would have been 2 grade levels behind in that skill.
One moment, Your Honor. Near the end of the questioning with the state, you provided an opinion.
I mean, I imagine I did. I think I may have provided more than once, but I'm not really sure what you're referring to.
Yes. Well, you didn't evaluate Aiden. You didn't provide any tests to Aiden.
Right.
Correct?
Yes, ma'am.
And as a trained psychologist, you know best practices would be to actually perform an evaluation upon it.
Right. Best practice is to do that. The desire is to do that. But if we can't do it, it doesn't mean we're not able to perform an evaluation. We're just, relatively speaking, there's a limitation that I mentioned. So we have the records we can evaluate him on, but I couldn't evaluate him in terms of what he had to offer me or doing any testing specifically with him.
So today, without an evaluation, you can't give an opinion about any personality disorder, or I should say his IQ, for example, where there's actual testing. You cannot provide an opinion on that.
No, I can't without seeing some hard data, which I don't have.
Now, how much do you bill the state per hour on this case?
I billed $250 an hour.
And ultimately, because I know your final billing hasn't gone in, how many hours will you bill on this case?
I mean, I would just be guessing at this point. I haven't added it up, but I would say probably 50 hours, maybe a little more, a little less.
One moment, Your Honor.
Redirect.
Yes, Your Honor. Dr. Pritchard, Ms. Peoples asked you in the very beginning, after she asked you about Baker Act information, about people that cut themselves. Could that be a sign of depression? And I believe you said it can. And she offered up and agreed there could be several motivations, correct?
Yes, ma'am.
Okay. Do you recall a specific reason Mr. Fucci gave his friend Michaela Harris about a cutting incident? If you don't, I can direct you.
I don't know. I don't know. I can't pull it up right now.
Okay.
So
If you would refer to page 11, the first full paragraph of your report, when you're relying on Michaela Harris for some of the emotional and mental health.
Okay, so page 11, first paragraph.
First full, where it says MH.
Okay.
Just read that and it might refresh your memory about the cutting.
Yes. Okay.
At least one comment he's made about cutting. What was that?
Well, he said that when he saw that Michaela cut herself, he thought it was the coolest thing. And according to Michaela, Mr. Fucci indicated that he had cut himself one time.
Ms. Peoples asked you a lot of questions about, and the obvious answer of no, you didn't evaluate him, you didn't test him. Would you have liked to?
Yes.
Okay. You were not allowed to?
I was not allowed to.
Okay. And you've described it's limited as you have to. It's without that, you're limited in how far you can go. And you stayed within the records review in this case and provided opinions, correct?
Yes.
Meaning you didn't provide a mental health diagnosis of Aiden Fucci.
I did not provide a mental health diagnosis. And, I stopped short of providing some opinions that I might have otherwise been able to provide because I wasn't given the opportunity to see him. But again, as I've stated, I had a lot of information on which to draw conclusions and opinions.
And then ultimately, Ms. Peoples went through some of the science or psychology that we understand is accepted commonly in your field about youth and brain development. And you agree with all of that, correct?
I do agree with all of that. It's scientific fact. I mean, that's why the juvenile laws were made, because they're not fully developed and they're different than adults. So yes, I believe in all of that.
Okay, so just so the court's clear, you're not here disagreeing with those general principles of juveniles?
Oh, not at all. No.
Okay. What have you done then based on accepting that premise of juveniles? They're generally immature, they're young, and their brains aren't developed. Knowing that information, are you drawing a distinction about this crime as it relates to that knowledge about juveniles?
Yeah, I am. And that's the thing. It's again, and I've said this several times, all juveniles on the planet, their brains are not fully developed. Okay, that doesn't mean that we're going to see egregious behavior from them necessarily. Occasionally we do, and we need to consider the variables. So the unique thing with Mr. Fucci is, given all of he's the same status with a not completely developed brain as every juvenile on the planet. And understanding that and acknowledging that, he still chooses to do something that is extremely rare for his group of peers, the sample we compare him to. So that's the relevant point for him as an individual. even though we know all this other stuff about juveniles in general, it's extremely rare and very, very different.
Okay, no further questions.
May this witness be excused. All right, thank you, doctor.
Thank you.
All right, at this time, that would conclude the testimonial portion other than victim impact statements for the state.
Yes, Your Honor. We're going to take, I think, a portion of her motion
Yeah.
now, and then if I could just confer and make a decision on whether we start today or tomorrow, that would be
Okay.
great.
All right, Ms. Peoples, I did receive your motion to strike cumulative, I believe there's a typo in this motion, but cumulative community letters and restrict victim impact evidence. I do have that motion in front of me. I'll hear from you at this time.
Our defense would move to strike I believe it's in excess of 130, nearly 150 letters that are.
You're going to have to move to the podium.
So we had filed a motion to strike the community letters and restrict the victim impact evidence in this specific case. Miller v. Alabama, and that's the basis for Florida Statute 921-1401, is governed or is in keeping with Miller v. Alabama. These statutes are written because children are supposed to be treated different and kids are different. Aiden Fucci is before the court. He has been direct filed on an indictment of first-degree murder, and he's entered a guilty plea to that offense. And we're here before the court for a sentencing hearing. However, the nature and the volume of the letters that have been placed before the court is now raising concern, and that's why we're filing this motion, that the court would consider these, would in essence deny him his constitutional right to a fair hearing at this juncture. So we're asking the court to strike the letters. I understand that the state is arguing that on 921-1401, that there's two different subsections addressing the community. But we're now dealing with a volume and relevancy issues that are overborne our ability as defense counsel to represent Mr. Fucci. So I'm asking the court to strike the letters, and that in terms of the victim impact, again, the state will rely on the same statute, 1401, in terms of having the family speak and address the court. And it's not uncommon to have family members come before the court on criminal matters or any criminal matter. The issue is the content of what they're before the court with. So we've placed before the court a motion addressing these issues that, including the victim impact, there are restrictions and that they're not free to trample over the defendant's constitutional rights. So we filed the motion, Your Honor. We're asking to have a reduction in keeping with, and I know the case is cited here that it's a thumb rule of 4 members of the family to address the court, and not have, I believe the state has indicated it was 6 and 4, so 10 individuals before the court for the purpose of victim impact and effect on the community. And then I'll rely on the motion for the additional argument. Thank you.
Thank you. Stay.
Thank you, Your Honor. Well, the first, I think, issue with the defense's argument is that the quote unquote rule of thumb that she cites applies very specifically to death penalty cases. And as the court is well aware, the reason for those rules is that courts have time and again said death is different. Those cases are very unique. The other part is that those are victim impact statements that will be presented to a jury who's going to decide whether the defendant, whether to recommend a death sentence or not. We're not in that type of case. There's no jury here that's making any decisions. Only Your Honor is making that decision. So those cases don't apply under this circumstance. One of the issues that they have is that the number of letters in this particular case, this is a very unique case in that, a lot of the cases we have affect only a small handful of people, family members and maybe a few friends. And the victim impact statements that are given in this case correspond with that type of impact. This case is unique in that it had a wide-ranging impact on this community. The Bailey family is a large and loving family. There's not just mother, father, sisters, brothers. There's grandparents, there's cousins, there's people in this community who are greatly impacted by this particular people that Tristan Bailey went to school with. All of them were invested in Tristan Bailey, and this greatly affected them. The only case that the defense cited for dealing with the number of cases was this Hamilton case. And that case is distinguishable from this case in this respect. In that particular case, and this was really dicta in the case, because the court had already overturned the conviction in the case for other reasons. And it made this side note that during the sentencing hearing, the prosecutor in that case told the judge that he had a petition that had 3,000 signatures on it that demanded the maximum sentence. Well, this is different in this respect. We don't have a petition demanding the highest sentence. We have 130 letters, approximately from each of these individuals who are going to tell the court exactly how this crime affected them. It's not a demand that the court sentence Aiden Fucci to life. It is specifically to say, this is how this crime that was committed by this defendant affected me personally. The other part of this is when it comes to these victim impact statements, they're only one factor that the court has to consider. We're not going to sit up here and tell Your Honor that you should only listen to these 130 letters. That's only one factor the court can consider. What we're going to tell the court is everything that the court has heard today in terms of all of the other factors in the sentencing statute, the court should consider. This is only one part of that. And again, as I said before, this is not to a jury where there's a risk that the jury can be so overwhelmed by the sheer number of letters or sentiments. The court can look at these letters in the proper context and can decide what is appropriate to consider and what's not appropriate. And I trust the court's judgment to do that.
All right, thank you. Anything else from the defense?
Your Honor,
The state provided Serrano v. State, and there are distinctions between Serrano v. State and Aiden Fucci. There is an objection, and that was one of the first issues that they addressed, that there was no objection in the lower court in Serrano v. State, and that there's some indication that the court considered the family member's opinion at sentencing, which we're trying to address right now. So I would say that this is distinct, and that, again, that the Eighth Amendment that we've had says, even since identifying that these particular juvenile cases, that the kids are different, death is different, but that we treat these juvenile cases with the same attention that we do with the death cases, that it's heightened by nature of the age of the defendant and by nature of the direct file. So I understand the state has provided this case. I do believe that there are some distinctions, and that in the case that we did put forth before the court, that the state is correct, it was a petition. So you're looking at a couple of pages with thousands of signatures. The distinction here is that we're not dealing with one petition, we're dealing with an excess of 130 letters. So I do think there's some similarity with the case that we presented in the motion. Thank you.
Thank you. Mr. Johnson?
Yeah, and I'm just going to speak again, she mentioned the Serrano case, which I didn't mention before, but I had emailed that to her, and I emailed it to your Jay.
I have not seen it. So
Miss Davis was going to I asked her to send it to you because I didn't have your
Maybe
email,
she
Judge.
did, but I hadn't checked my email since we've been sitting here. So
I can give you the case site, Judge.
let me see if she sent it to me. I have it. It's sent at 4:21.
You did receive it.
I received it 5 minutes ago. Let
Yes,
me
sir.
look at it real quick.
And it just simply said that the family is permitted to address what they would like to see the court do with the sentence. So.
Hey, you guys, look at this really quick.
You things take my soul. You things will take my soul away.
I certainly looked at this and said, whoa.
Jacksonville attorney Shannon Schott, who specializes in juvenile defense, said the orange jumpsuit.
So he was trying to like act like he was. Let me go back. He was trying to act like he was
and
crazy.
Others.
I won't let you demons. I won't let you demons take my soul. You demons will take my soul away.
I certainly looked at.
And at one point, he was like, "Where am I? Where did I get here?" I'm sure y'all saw all that, but I was trying to find that while we were watching this other thing. Okay, let me get rid of this case. Nah, they still got it muted. So he's a little, that's part of his little con game that he's trying to act like he's insane. I saw your, Blue, I'm going to look at that video. I don't want Law and Crime to strike me, so I think I might make a little mini video on my own, put some commentary in it, and put it up tomorrow because they might strike me if I play that on my channel. Very manipulative, Blue. Very manipulative. Oh, shoot. I thought I shared the screen. I didn't share the screen. Hang on. Look how young he looks. He's just a baby. So let me ask you this. If he does get, after he gets sentenced this week, is he going to go back to the same place? Or is he going to still be in his little bat cave, in his little around the younger kids, I understand they can't place him with adults at his age. Because I don't agree with them placing him with adults at his age, but surely there's a more harsh place for him to go. All right, I'm going to leave this on with the sound, and I'll be right back, guys.
Case. It was emailed to me, 279 Southern 3rd, 296, Serrano v. State. I'm going to deny the defense motion to strike cumulative community letters and restrict victim impact evidence. First of all, the court has begun reading the, is it 130 state? Is that the correct number?
It's approximately.
Okay.
I know we submitted a little over 130 or approximately. The family did come into possession of a few more just this morning. It handed me a few more, one's from a direct family member that we were going to submit.
I have begun reading them. I do agree with the defense in the one aspect, and that is that many of them do request a particular sentence. Obviously, the court is not reading or reviewing the community impact letters and taking that into consideration, but certainly I am taking into consideration the statements or the impact that this crime had on the family or the community itself pursuant to, again, 921.1401. So I'm not going to strike any of the community letters. I will obviously review them for the relevant value, which is, again, in determining under 921.1401 the effect of the crime on the victim's family and on the community at large. All right, so that motion is denied. Let's talk about the number of impact statements that you plan to present.
Your Honor, there are two persons here today that wouldn't be able to return, so I figured I could start with them, and then we can pick up in the morning if Your Honor would like after that.
How many total are we going to present?
There's 6 direct family members. And then we have 6 from community members, which would be an assortment of teachers, coaches, and good friends, juvenile friends of Miss Bailey.
Well,
Some are to be read by, one is going to be read by Mr. Johnson, one's read by the victim advocate, and the rest would be in person.
Are those letters, the ones that are going to be read by the victim advocate and Mr. Johnson, are those community individuals or are those family members?
Those would be not family. They would be, they're from the community and close relationship to.
I have
family.
a copy of those.
No, you do not. These, we
Present-
have these back.
Present those to me and I will read those myself. I don't need them to be read in open court. If they're from family members, that would be different.
Okay.
But we were already looking at 12 victim impact statements. So we're going to reduce that at least by those 2. I will review those letters myself.
Yes, sir.
The victim impact statements from the family members, obviously, we'll hear from all of them. And then the other, I guess, 4 community letters or community impact statements you can present. Now, 2 of those going to be read today.
Yes, sir.
All right.
Yes, sir.
Do you want them to sit in the
I
witness
think I'd
stand?
rather have them sit just in case.
That'd be fine.
Okay. Now, this time the state would call Bree Cherry.
This is going to be interesting.
Bree Cherry.
All right. Ms. Cherry, go ahead and have a seat in the witness stand. Make yourself comfortable and try to speak into that microphone, okay?
Yes, sir.
All right.
And Ms. Cherry, before you just read your letter, for the record, state your name and your relationship to Tristan Bailey.
Yes, my full name is Brianna, Brianna, last name Cherry. And I was Tristan's all-star cheerleading coach.
And you can go ahead and read your letter.
Good afternoon, Your Honor. As I just stated, my name is Bree Cherry, and I was Tristan Bailey's all-star cheerleading coach. I've always referred to my athletes as my cheer children because that's what they are. During peak season, I would spend more time with my cheer children than I did my own biological ones at home. In the cheer world, not only do these kids become yours, but these teammates become family. They spend countless hours in the gym, forming a sisterhood through blood, sweat, tears, hugs, high fives, and hit zeros, which is when they hit a perfect routine. It's an unbreakable bond we all experience in a community like no other. I tell you all of this so you can get a small grasp of what Tristan meant to her coaches, her gym, and her cheer sisters. There's nothing in the coach's handbook that could have ever prepared me for what I would face on the horrific day that was May 9th, 2021. I was in Orlando, Florida, coaching at the Cheerleading Worlds, where just 1 week before, I stood in the exact same spot with Tristan as she competed at the summit. I'm sorry about that. Okay. The summit was the Super Bowl of cheerleading for Tristan's team and age group. We were on top of the world after having an incredible showing at the biggest competition of the year. We were so excited for the future of these young athletes and all of the incredible talent we would be starting the new season with. Then 1 week later, our lives changed forever, and not for the better. Aiden Fucci selfishly took Tristan away from so many people who loved and needed her. Our team lost its leader. These athletes lost their sister. And I lost a piece of my heart that I will never be able to get back. I wrote this letter to speak out for myself, but to also speak on behalf of Tristan's cheer sisters, whose lives will never be the same. Tristan's teammates' ages ranged from 8 years old to 13 years old. And the impact didn't just stop at Tristan's teammates and coaches. You see, we had 200 athletes in our gym, and those athletes have siblings, parents, aunts, cousins, grandparents, etc. All of these people make up our gym family. When you have the heart and the personality that Tristan did, your impact stretches far beyond those in your immediate corner. We all gathered to grieve, and the image of these kids on their knees, screaming and sobbing as no adult could console them, will be etched into my memory forever. In the days to come, not only are we mourning the loss of Tristan, but we're forced to hear the horrific details of what happened to this person we love so much. How do you tell an 8-year-old child it's going to be okay when they have to hear from the world around them that she was brutally murdered by her schoolmate? It's our job to protect our children. And due to the nature of this crime, there was no way to hide these details from these babies. These details will continue to haunt each and every one of us on a daily basis. There's nothing we can do to fix the hurt, remove the fear, or bring Tristan back. And unfortunately, as these kids get older, the pain will only become more severe as they bring their own children into the world and try to protect them from evil. I come to the court pleading for the maximum sentence for Aiden Fucci. Even more, I beg and plead that the person reading this letter 25 years from now will think about all of these kids and what they've been through. The complete fear and terror we would all feel knowing the complete fear and terror we would all feel should any sort of release ever be considered. The Bailey family and each and every person who knew and loved Tristan has endured enough. Because of his age, Aiden Fucci cannot receive the death penalty. He gets a chance at life. Tristan didn't get that chance. The years will go on for him, but our reality is that this horrific nightmare will never end. Our hearts will break every single day for the rest of our lives because Tristan is no longer here. Thank you for your time and consideration now and in the heartbreaking years to come. Tristan Bailey Strong. Thank you, Your Honor.
All right, state.
Your Honor, we would call Susan Thistleton.
Have a seat, make yourself comfortable, man. Just that microphone so that you're not right up on it. Okay?
That's good.
Yes, perfect. Thank you.
Good afternoon, Your Honor. My name is Susan Thistleton, and I'm a teacher at Patriot Oaks and the mother of Tristan Bailey's classmate, Cameron Thistleton. I'm reading you an abbreviated version of my impact statement. I have submitted my letter and my son's letter, and I hope you have a chance to review. May 9th, 2021 was one of the worst days for my family that I can ever recall. What started out as a fun, relaxing day on the water with my children for Mother's Day turned into every parent's worst nightmare. First, we got the text, "Has anyone seen Tristan?" My first thought, she snuck out, fell asleep at her friend's house, and just hadn't woken up. Her parents will hear from her any minute. Hours went by. My children and I waited for updates. Our next update was that she might have been seen with Aiden Fucci. My heart sank. I didn't know Aiden. I never met him, but I knew of him. And right then and there, I knew it wasn't going to end well. I stayed glued to my phone, neighbors, coworkers, and friends, praying for good news. Then news came that her body was found in the wooded area. Now I was faced with the task of telling my 13-year-old son that his friend and classmate was dead. He would immediately know who was responsible. We all did. Why was this so hard for me? My son Cameron came to Patriot Oaks as a 4th grader. We had moved to Florida from Colorado. Cameron had some academic issues, and he had some behavioral issues, and we were constantly trying to help him with those. His behavior often alienated him from other kids and made him feel inferior to others. In all that time, Cameron had one constant and immediate friend, one person who never judged him, never alienated him, and never made him feel worse than he already did, and that was Tristan. She was a constant source of support, friendship, and positivity that Cameron needed. She made him want to do better, to be better. She was his true cheerleader. I didn't fully understand the impact she had on his life until she was gone. When I broke the news to Cameron, he was crushed. He sobbed, he asked why, he got pissed. He asked so many questions and had so many wonderings. Mom, did she suffer? Did she know he was trying to kill her? Do you think she was cold? Aren't boys supposed to protect girls? I could not answer any of his questions, so I just held him tight and cried with him. How do you begin to process those questions? Cameron missed several days of school after that. He could not hold it together. The anger consumed him. He just could not understand how anyone could be so evil to hurt someone in such a violent way. He was very angry. We attended counseling for months. My husband and I were so worried that our son, who had come such a long way since 4th grade, thanks to Tristan, would slide backwards. He has struggled, but he has worked to be the light. He knows he cannot let anger win. Tristan would be incredibly mad at him. Cameron no longer has behavioral or academic issues. He is thriving. And I know in my gut and in my heart, Tristan's constant source of love, support, and friendship in the 4 years that she was his classmate played a critical part in getting him to where he is today. Our family thinks of Tristan daily. We try to do good in her name. We just can't help but think how much better we could do if she was still with us. If only I could thank her for the kindness and the grace that she showed my son every single day. She truly embodied the quote, "In a world where you can be anything, be kind." And for that, this mom is incredibly thankful for the amount of work that she did in such a short period of time. We are devastated that she is no longer with us to be the bright light that she brought to Cameron. Anything less than life in prison would be an insult to the goodness that Tristan brought to our world. What he took away from us is 100 times more devastating than what he could ever add to this world. We will continue to fight the good fight, to be the light, and to do good deeds in Tristan's name. We will not let hate, evil, or violence win, ever. Thank you.
Thank you.
Oh my gosh, my heart hurts.
Let me ask.
Yeah, I don't think he's going to react, you guys. I don't think he's going to do anything special. I think all in all, he's a little coward. The parents want to have plenty of time to speak, so don't rush them. So I guess the parents will speak tomorrow.
Make yourself comfortable. Take your time.
Hi, Your Honor. Am I loud enough?
I think you're good. Yeah.
Okay. Okay. My name is Jennifer Van Delden. My family has known the Bailey family for over 10 years. Tristan Bailey is like a daughter to me and like a sister to my daughter, Madeline. I consider Stacy and Forrest to be two of my closest friends. The pain from losing Tristan in such a violent way is not something you ever get over. It is something heavy that will weigh on my heart every day, and I will carry that pain forever. When I close my eyes, I think about the pain she must have suffered that night. And I wish so very much that I could take that from her. I always pray to myself that in those final moments, she was able to close her eyes and see the faces of family and friends who loved her dearly, rather than the person capable of something so horrific. My new normal since May 9th of 2021 has become living with diagnosed depression, anxiety, migraine, and cluster headaches, many panic attacks, difficulty sleeping, and extreme fatigue. This loss has caused so much stress to my entire family. My 11-year-old son, who was 9 years old at the time, and Tristan spent time together to and from school for many years. They also spent time at family dinners, swimming, and so on. My son always picked on his older sister and her friends. In his 3rd grade year of school, his innocence was stripped from him. On Monday, May 10th, 2021, I asked Oliver to wear white to school in remembrance of Tristan. He went into his room to change, and he didn't come back out. I found him crying and so distraught about Tristan being gone. He was so worried that Tristan didn't know that he loved her like a sister. He missed that entire week of school. Because, of course, how was a third grader supposed to cope with this kind of violent loss committed by a child who also attended his school? My daughter, Madeline, was in 8th grade at the time. She was very afraid to return to school and missed many days. She failed a depression questionnaire at her routine pediatrician visit. She started having frequent, debilitating headaches, even into her 9th grade year, that caused her to miss school and many assignments. In May of 2022, a few days after the 1-year anniversary of Tristan's murder, Madeline had a severe headache in Mass in church. She stood up, passed out, and began having seizures. She was taken by ambulance and held for observation. This was most likely stress-induced. My once happy-go-lucky little girl, who was fearless and independent, was now waking up screaming from nightmares, crying every day, not sleeping alone, feeling sick and overwhelmed by daily life, and was just overall sad missing her friend. Not just Tristan's life was taken that day. A piece of everyone close to her was taken as well. I used to think about cute stories I'd share at her wedding one day. We used to joke about it all the time, embarrassing stories, I would say. Now we'll never have that day. I hear new songs on the radio and think, she'll never hear this. There will be no more thoughtful birthday texts, no more Starbucks runs, no more hugs, no more air hearts before she went into her house when I was dropping her off. Not a day goes by without tears. Life is forever not as bright as before. I wish every day that I could hug her one more time, but even then, that would not be enough. Aiden Fucci, that day, a piece of me died as well. My happiness will never be the same, and my ability to be carefree is gone. That's it.
Thank you.
Thank you.
It's 5 minutes till 5. This is probably a good stopping point for the day. We'll come back at, if I could have the attorneys here by 10 till 9, and then we'll continue with the victim impact statements at 9 a.m. And then you'll be ready to proceed on your case.
Thank you, Your Honor.
Okay, we're adjourned until 9 a.m. tomorrow.
All right, you guys heard it. 9 a.m. their time. What is that? 8 a.m. Oh, is that 8 a.m. our time? So tomorrow we're going to do the Fucci trial. Are you guys in it with me? Y'all going to be available? I'm just so glad she said his name when she read that. I'm so glad that Blue says I need the wormhole. I know. I think I'll find out some stuff tonight on this little pervert, and then tomorrow we'll get some relief when we hear him sentenced. So with that being said, y'all have a blessed night, and I'll see you in the morning. I'll be posting up the live stream here in the next few hours. Thanks, everyone.